Welcome to everybody. Thank you very much for assisting in the second day of the conference. Thank you especially to our speakers today. I think everybody who was here yesterday will agree that we had a fantastic first session looking at both cases in Europe, cases in the United States, looking at this issue from the perspective of law, from the perspective of historical studies, Ganoon Diop bringing in a philosophical perspective. Today we're going to continue in that line that was established. Our first session, which will be chaired by Rosa Maria, will focus principally on European case studies, and the second session chaired by Brett will focus principally on the United States. I'll let Rosa Maria present the first speakers. I'll just say in terms of format, if you'd like to ask a question for one of our speakers, if you could just signal the question in the chat function. You can do that whilst the speaker is presenting, or you can do it afterwards, and then we'll collect those questions as we go along, and then maybe Rosa Maria will also have some time for some back and forth, depending on how much time we have left. So without further ado, I'll cede the floor to Rosa Maria.
Thank you, Alexis. Thank you so much. Well, good morning, America, I would say first, and good morning, Europe. Our audience is very welcome today to the International Conference on COVID-19, our pandemic and religious freedom, and we are going to have reports from Europe, mainly from Europe. As we mentioned in the previous session yesterday, the aim of our conference is to bring together experts from North America and from Europe to develop a comparative analysis of the impact of COVID-19 restrictions on religious freedom. And now that is what we are going to address. It is a true pleasure to introduce two experts of the Office of the United Nations High Commissioner for Human Rights. I refer to Dr. Ibrahim Salama and Dr. Michael Weiner. Let me explain something about them. Of course, they are very well known, but I should mention something about his bio. Dr. Ibrahim Salama is Chief of the Human Rights Treaty Branch at the Office of the United Nations, and he also leads the Faith for Rights program. His presentations has to do with the Faith for Rights program. Previously, he headed the United Nations Secretariat for the preparatory process of the 2009 United Nations World Conference against racism. He was an independent expert of the Subcommission on the Promotion and Protection of Human Rights, and he was elected chairperson of the Intergovernmental Working Group on the Rights to Development. Well, it is my real pleasure to give you the floor, Professor Ibrahim Salama, on the topic that you had presented concerning this important, you are learning exercises, you are learning expertise concerning the Faith for Rights Toolkit. Please, go ahead.
Thank you very much for this opportunity to exchange with you our ongoing experience that I would qualify as an attempt to reconcile religious and human rights approaches to their same goals. Undoubtedly, the COVID-19 context aggravated the situation and unpacked or uncovered the fragility of many of our approaches and structures, including how human rights community and discourse deal with issues of religion and the challenges that this raises. My intervention will try to situate the overall framework of Faith for Rights. Where is it coming from, and what are we struggling with at present? And I will leave to my colleague Michael Wheeler to zoom in particular on the content of the Faith for Rights commitments with special emphasis on what relates to the COVID-19 context. Of course, it was not there when we imagined this framework, but it's a living document, the Faithful Rights framework, and that's what allowed us to adapt to the current situation. First, about the backgrounds, and I think this could be of interest to researchers in particular, and also they lend themselves to a comparative view between how the same issue is lived and dealt with in the Americas and how it is in Europe and in other parts of the world. So the background, you mentioned, Rosa, that I started my work with the UN as responsible for the Durban Review Conference. And in fact, one of the main seeds stroke symptoms of the tensions between religion and human rights was one of the landmines of that conference. By this, I mean the issue of religion and the notion of defamation of religion that some countries wanted to have in the outcome document of the Durban Review Conference, considering that denigrating religions is part of the manifestations or the contemporary manifestations of racism in one way or another. So one of the lessons we learned at the Office of the High Commissioner in that conference, it is that we need to unpack and clarify many issues relating to religion and human rights. At that particular conference, the then High Commissioner for Human Rights, Navi Pillay, promised to organize a series of expert-led workshops to unpack the relationship between Articles 19 and 20 of the Covenant on Civil and Political Rights. And this is the freedom of expression on one hand and the prohibition of incitement to hatred on the other hand. So that was one of the areas of tension between religions and human rights when faith traditions are being used in a way that incites to discrimination or violence. Is this a tension between freedom of religion and freedom of expression and the other human rights on the other hand? Or is it a misunderstanding of one, or is it a misunderstanding of both? So these difficult questions were in a way probably either not too pressing or the comfort zone of trying to deal with them from the certitudes on both sides seemed to be the prevalent attitude. So that was one of the areas of tension. There are many other areas of tension between religion and human rights, and it's wrong to deny them, but it's even more wrong not to unpack them. So that was the first background. Secondly, there are numerous reservations on human rights treaties, and that what exposed me particularly more intensely than many others in this, because I'm dealing with state reviews and submission of reports to treaty bodies, and I found a lot of the engagement, reservations, and replies and justification of non-abidance by some recommendations by the treaty monitoring system were founded on religion, rightly or wrongly. So another manifestations of the latent contradiction. And then in the development of the current times, all these backgrounds were there with us for a number of decades already, accelerated but relatively old as human rights probably. But lately, in the past decade, I would say immigration, globalization, and demographic trends made all our societies in a very accelerated manner much more multicultural and multi-religious than before. And we see that this does not happen easily, even in democratic and secular countries. You see the recent tensions in France and the complexity of the issues it raised, and one realizes that there is some undone homework in terms of honest academic and political unpacking of what are the tensions. So we took it from the Durban Review Conference in 2009 onwards. We took the 4 years from 2008 to 2012 to organize these regional workshops where we were asking an expert from the region to lead as a consultant, and he or she would be trying to gather data and analysis and views on three levels. What is the threshold of incitement to hatred in the legislative approaches, in the case law, and in the public policies? and what was the role of religion and responsibilities of religious actors in this respect. So at the end of these 4 years, we reached the Rabat program of action, which was not only limited to the responsibilities of faith actors, but it started to include them with specific responsibilities in this area, along with many other concerned stakeholders, including the media, the education, the parliaments, and of course the executive authorities and the public policies. So this was one of the first attempts whereby we reached a clearer understanding on what's the threshold, and the famous threshold test that distinguishes hate speech from freedom of expression, we believe filled an important gap, and Michael will give examples how this was taken by practitioners who are much more in the middle of these dilemmas on instant, not only daily basis, instinctive basis, like Facebook and others, for example, the content moderations Michael might wish to touch upon. As one concrete manifestations of where does the clarification of the relationship between religion and human rights can be beneficial in practice. Once we reached Rabat, we started to realize that we were encouraged by the results and the utility in practice. So we started inquiring in a larger spectrum of all human rights, what are the relationship between religions and human rights. So we started to have, instead of the progressive approach focusing on one problem at the time, this was the case of hate speech, we started the Faithful Rights Framework, which was again a consultation with among faith actors and human rights civil society experts who work in the area of freedom of religion and human rights at large. So in a way, it was built on what I call the double convergence. What is it that exists in common between different faith traditions, and how does this relate to the human rights universal values and standards and norms in human rights conventions? And the end result was a number of commitments articulated by those experts in a number of preparatory meetings that culminated in Beirut in 2014, which led to actually 3 documents. And it's important to explain them because it could be confusing from outside. The first document is the Declaration of Beirut itself on faithful rights. And the second one is the 18 faithful rights commitments the same year. And then 3 years later, we moved them towards the Faithful Rights Toolkit, which is a manual for practitioners of the management of religious diversity. I think this is the nearest to definition to what these 3 documents try to achieve: how to manage the religious diversity in a way that respects, not only respects, but even strengthens the human rights discourse and action by bringing the missing actor, who is the faith actors, into this debate. As Michael will explain, those 18 commitments are the Beirut Declaration is like the preambular and the conceptual clarifications needed, and it basically contains 5 fundamental principles that lay the methodological and even the political, quote unquote, ground of the engagement between faith actors and religious leaders. Number 1, it is to transcend the dialogues, interfaith dialogues, into action-oriented collaboration. Number 2 is to avoid theological or doctrinal divide, i.e. act on what's common between all religions. Number 3, introspectiveness, in the sense that faith actors, when assuming their role and responsibilities in the area of human rights, they should start by looking at their own community, at their own faith traditions, instead of the usual finding the thing always elsewhere before one's own sphere. Number 4, speaking with one voice on all the issues on which they decide they can and should do so. I think this is the heart of the ethical responsibility that they take, instead of the history-old defending one's own faith and tradition, probably against the others, into defending the faith community at large as one belief, insofar as they have much in common that can be articulated. Number 5 is to act fully in an independent manner. And that's why this document was not initially, but not at all excluding them, but not initially addressing or targeting the state official religious institutions as such. Not that they are not independent, of course they are, or they should, or they may be, or they become, but in any cases, it was addressed to the non-state faith actors, and that's also a novelty. So in a way, this document aspires to provide a tool that is based from the generalities or the preamblers of the Beirut Declaration to the specifics of the commitment, which is the core standard setting of the whole exercise, into the toolkit, which is the methodological, hopefully creative and living document by which faith actors are encouraged to become owners of their own human rights responsibilities that they define in these 3 documents. I will leave you now with 2 or 3 questions that we are struggling with, and I will end on this because Michael will zoom more on the content of the commitments and on our current attempt. But in those our current attempts of piloting as a peer-to-peer learning methodology, we're struggling with 3 questions. Number 1, how can we get a fruit? What are the possible takeaways from engaging, using these peer-to-peer learning techniques that brings, it's always on inter-religious basis, and ideally between faith actors and human rights actors. Number 2, how can we empower facilitators to use it? It needs a particular skill. It needs interdisciplinary knowledge. Otherwise, it can be, in a way, even dangerous at times, because instead of diffusing tensions, you can actually exacerbate them if you are not watchful and knowledgeable. And that's what we tried to cater for in the toolkit by having tips and guidance to the facilitators of the peer-to-peer learning. Number 3, how can we develop this tool in light of the lessons learned? And how can we create links between the practices? Like now, the whole purpose of this conference is to compare notes between Europe and the United States, so or the Americas at large. But we need larger than this. Those are not the only 2 regions of the world where these problems are there. So what is the best smart way to draw lessons together and to capture them somewhere through which the future practice builds on it and not just reinvents the wheel? Thank you very much, and over back to you.
Thank you, Professor Salama. Thank you for your relevant and explanation concerning what were the beginning of this faithful rights tool. Well, what I mean is that if you go to Durban was a starting point of many of the original ideas that have been developed after that. And now is the turn of Michael Winner, who is going probably to explain a case study how you develop this toolkit. Please go ahead.
Many thanks, dear Rosa Maria. And as Ibrahim mentioned, the idea is now to really zoom into the recent Faithful Rights Toolkit and really to showcase some of the examples and peer-to-peer learning exercises that are directly relevant to the COVID-19 context. And in the chat box, I just also included the hyperlink to the PDF file of this toolkit. And as Ibrahim was mentioning, this is actually really a living document. We are already at its 11th edition within less than a year. So it's roughly 1 new update or new revision per month, which actually at the current situation with COVID-19 has been very useful, because as the situation has been evolving, a PDF file can be easily updated, and any new guidance, any new practical case studies or specific examples, exercises can easily be included. In my short presentation, I wanted to focus on 3 modules in that toolkit. Modules 5, 6, and 16, which is basically gender equality, minority rights, and ethical and spiritual leverage. Because in these three modules, you will find really several pages actually of exercises, of facilitators' questions that are precisely trying to guide and help demystifying this link between religions and rights, as Ibrahim was rightly mentioning. And perhaps to immediately jump into this module on gender equality, because there the task of a facilitator of any of these peer-to-peer learning exercises is quite daunting. It's really difficult because he or she needs to really bring people together, and peer-to-peer learning, as Ibrahim was alluding to, it's not a top-down, I tell you how things are, but it's really at really a horizontal level, trying to understand from each other personal experiences, what works and what doesn't work. And here, obviously, the idea is precisely to have a free exchange and really also discussion, which may be also heated. So in that sense, what the toolkit tries to achieve is precisely to give the tools to the facilitator and to all participants, actually, how to address the hot potato issues. And obviously, gender equality, module 5, is one of the hottest potatoes that you can imagine. So here, just to give you some concrete questions that the toolkit offers to the facilitator, that he or she could pose to the participants. So what are the most challenging consequences of COVID-19 in the participants' areas of work? How do they particularly affect girls and women? What are the areas of actions where faith leaders believe they have the highest chance to make a difference? And this difference can be either positive or negative. So obviously in the context of gender equality, the pronouncements of religious leaders can be really hitting the ground, very important. In April already, just to give you a concrete example, the Committee on the Elimination of Discrimination Against Women, one of the UN treaty bodies, issued a call for joint action in times of COVID-19. And in that joint call for action, there's also a specific reference to peer-to-peer learning webinars in collaboration with Religions for Peace and other partners to explore how various faith communities can scale up collaboration around the diverse challenges posed by COVID-19 with a human rights-based approach with respect to women and girls. And that these webinars will use the Faith Rights Toolkit as a resource. So here already in April, we together with treaty bodies, OHCHR, and faith actors, notably Religions for Peace, we already put this on a peer-to-peer learning track. We have done several webinars. I mean, for example, 2 with Religions for Peace, which yielded more than 2,000 views on Facebook. One on confronting COVID-19 from the prism of faith, gender, and human rights, and the other one on keeping the faith in times of hate. Now going to the module on minority rights, which is module 6. Here, again, you have very obvious links and challenges, specifically for minorities posed in the COVID-19 context. You can think about overcrowding housing conditions, which obviously make physical distancing and self-isolation difficult. Minorities may be more likely to be excluded from healthcare because they lack resources or official documentation, or there may be stigma, discrimination, or hate speech. So again, in that context, the toolkit offers specific questions that the facilitator could ask, how, for example, to disseminate accurate evidence-based health and scientific information on COVID-19, and how this could, for example, draw from the language from the faith traditions to promote positive messages, and also to inspire hope and resilience in those affected by COVID-19 or who are facing hate speech in that context. So again, the toolkit puts together the various public statements, for example, by the Special Rapporteur on Minority Issues on freedom of religion or belief. The Human Rights Committee has issued clarification when it comes to emergency measures in COVID-19 context. The United Nations Network on Racial Discrimination and Protection of Minorities issued a statement. There was a guidance note by the United Nations on addressing countering COVID-19 related hate speech. And OHCHR also issued guidance on COVID-19 and minority rights. Just coming back to Ibrahim's point earlier on concerning the Rabat threshold tests from the Rabat Plan of Action, precisely trying to demarcate the fine and difficult to find line between free speech and hate speech. And here, I think the key added value of this Rabat Plan of Action is precisely these 6 different tests, which are designed to help adjudicate, basically, ideally by a judge, a specific statement, whether or not that reaches the threshold of Article 20 of the International Covenant on Civil and Political Rights. And as Ibrahim mentioned, this year, we have been approached by Facebook, which saw also the utility of this threshold test, and also the former Special Rapporteur on Freedom of Expression, David Kay, had also suggested precisely the use of this threshold test, perhaps with some adaptation in the context of social media companies. So thanks to this cooperation with Facebook, we now have available 32 languages, translations of this Rabat threshold test. And I think this is a very important tool for example, content moderation purposes, say in Burmese, when you have the question, does a specific statement in Myanmar, for example, against Rohingya, or in the COVID-19 contexts, anti-Semitic, anti-Muslim, anti-Christian, or Hindu, Baha'i, you name it, and to really see whether or not this reaches the threshold of Article 20. The third module I just wanted to briefly touch upon is module 16 on ethical and spiritual leverage. Again, here already in March, Religions for Peace issued a statement on the coronavirus crisis, where it referred to the Abu Dhabi statement by Pope Francis and Imam Al-Tayeb. And then immediately afterwards also said, and I'm quoting, a compelling way to translate ethical values into concrete actions is to promote human rights, fraternity, and solidarity through the faith rights framework. And this framework and the 18 commitments reach out to individual theistic, non-theistic, atheistic, or other believers in all regions of the world to enhance cohesive, peaceful, and respectful societies. And to fulfill the responsibilities of believers in this broad definition of religion or belief, we encourage faith actors to use the online faith rights toolkit, unquote. I think that's, again, a very positive and early statement by this umbrella organization, Religions for Peace, which is then also picked up in the toolkit itself, posing specific questions to the participants of any peer-to-peer learning. How to, for example, conceive a project that alleviates any negative consequences in their local context. And what are the entry points in the 18 commitments on these issues? And what are the specific role that faith actors can play? And which practices in the religious sphere could either prevent diseases or increase the risk of their propagation? What are the lessons learned that may lead to preventive action by participants who could integrate this into their own work? So just to give you the flavor, that this toolkit is really designed to be hands-on and practical, not in a theoretical manner, but really inciting, in a positive sense, obviously, participants to think about their own actions and also to be creative and forward-looking. Just also conscious of the time, because I think I've got another 5 minutes, not more. There were also virtual consultations that the Office of the High Commissioner for Human Rights, together with the Alliance of Civilizations and the Office of the Special Advisor on Prevention of Genocide, organized in May. And actually, we are embarking on a series of webinars, which you may perhaps also be interested in participating. So this yielded the Global Pledge for Action by religious actors and faith-based organizations to address the COVID-19 pandemic in collaboration with the United Nations. And there, the High Commissioner also really noted the importance of having a one UN approach, combining the various different texts on hate speech, on safeguarding religious sites, the phase plan of action, the 18 commitments on faith rights, and the faith rights toolkit. And really to come together and have something practical with commitments, with concrete actions, and ideally in an interfaith manner. And just also to refer to something which the High Commissioner yesterday at an online panel hosted by ACT Alliance stated. She referred basically to these Global Pledge for Action and announced also this seminars, series of webinars where the role of faith actors is particularly influential in the COVID-19 contexts. And this specific list of pledges for action is really the key of going for collaboration and having also a community of practice. And this peer-to-peer learning will actually start next Monday with a webinar on gender equality and on the role of faith actors in achieving it. The approach is very much interactive by sharing good practices and lessons learned concerning gender equality. And the subsequent webinars on a monthly basis will focus on hate speech, religious sites, minorities, atrocity crimes, and interfaith dialogue. And all the information is available on the website that I also included in the chat box. Wrapping up, just to flag some concrete examples of practical engagement, also to give you a flavor of who we have been engaging with in the past 8 months, I would say. So conducting peer-to-peer learning events, notably with civil servants, for example, in Nigeria, with faith-based and humanitarian actors in Denmark and South Asia, and globally, obviously, with Religions for Peace, with academic institutions, notably Oxford University and Vrije Universiteit Amsterdam, and also with UN treaty bodies and special procedures, notably the Special Rapporteur on Freedom of Religion or Belief and students from more than 50 countries, together with UNICRI and Special Advisor on Prevention of Genocide. And in all these webinars, we have been using the Faith Rights Toolkit and its exercises related to COVID-19. It has been really very useful to discuss a hypothetical case study, which is based on real life elements. And you can see this in Annex G of the toolkit, which exemplifies the role and responsibilities of the state and religious leaders during an epidemic. And this peer-to-peer learning between civil servants, faith-based actors, and human rights mechanisms is, I think, really key to prevent any overreach of extraordinary measures and to safeguard civic space for everyone. And as my last sentence, basically, I wanted to share one real-life impact that we had when having these peer-to-peer learning exercises. One of the participants, a civil servant, actually said, "Why do you have all these funny names in this hypothetical case study in your toolkit?" Because actually the same case as you have in your toolkit, which in the fact was hypothetical, inspired by several elements from around the world. But she said, actually in my province, the same thing happened with a religious leader bashing another one and another one not wishing to end religious services, and then the politicians coming in and stigmatizing one community. So I think this was a positive example of seeing that even this hypothetical case is very much relevant, because unfortunately we see all these elements in real life, and all the more important to discuss them in a peer-to-peer learning mode. Thank you.
Thank you. Thank you, Michael. It was excellent presentation. Thank you for the many ideas you introduced to the discussion, because you mentioned modules 5, 6, and 16 concerning gender equality, minority rights, and religious for peace. I mean, you make a broader approach to the strict focus of the program, but I do appreciate, because I need, we all understand that COVID-19 needs to be contextualized, and human rights is the framework where it has to be contextualized on this occasion. Thank you so much for your expertise and for the example you gave us. Now, we are going to give the floor to the next speaker who comes from Italy. I refer to my Professor Alessandro Ferrari, who is a professor in ecclesiastical law and comparative law of religious at the University of Insubria, Varese and Como. He is director of the Research Center, Religions, Rights and Economies in the Mediterranean area, but his research interest focuses, as far as I know, on the transformation of the right to religious freedom in Europe and in the countries of the Middle East and North Africa area. He was visiting fellow at the Islamic Legal Studies programs of the Harvard Law School. He was director of studies invited at the École de Haute Études and visiting scholar at the Northwestern University. I think Alessandro is one of these scholars who is very promising because he tries to create bridges between Europe and America. And thank you, Alessandro, for you accepting our invitation. You have the floor.
Thank you. Thank you. I think that focusing on the Italian case, we will immediately see how it's difficult to establish bridges between America and Europe and America and Italy, taking into account the very different legal and cultural and religious context in which the idea of religious freedom has developed in my Italian context, for example. And in fact, for my brief presentation in relation to COVID-19, I focus on a very old paradigm because I think that COVID-19 is very interesting perspective through which to look at religious freedom, because one of most important point related to this crisis was the debate around the state of emergency. And we know that the state of emergency is very connected to the idea of sovereignty. And this is a very old Westphalian, modern Europe idea. And is also connected to the time when the right to religious freedom was born. And is also an idea that allowed us to look at the two dimensions of the right to religious freedom. One is an idea that we know now better, and maybe we are always focusing on this dimension, that is the dimension of religious freedom as a fundamental constitutional right, but we shouldn't forget the other dimension is the institutional dimension of the right to religious freedom as a right that put in question in relationship different legal orders. And I think that the COVID-19 case in Italy just is very important because has revealed the tension between these two dimensions of the right to religious freedom. I would like to go to try to explain why this crisis has revealed this tension between these two dimensions. So first of all, when COVID arrived in Italy and the pandemic was widespread, the Italian government declared the state of emergency following a procedure that is established by the Civil Protection Code. And this allowed the government to take very rapid measures of containment of the virus that severely affected many fundamental rights, the right to circulation, to conduct a business, cultural rights, right to education. And among these rights was eventually affected also the right to religious freedom, and in particular in its more
Well, I think something is going wrong with Alexandro. Can you hear me? Yes. Okay. Then shall we give a couple of minutes in order to get connection with Alessandro?
Maybe we could just go to Blondine, and then he's calling me right now. We're just
okay. Let's wait. Sometimes, well, the connection between Europe and America sometimes goes down.
So we're going to go to Blondine, and then we'll. So we should go to Blondine because he's had a power cut.
Okay, thank you so much, Alexis, for your help. Blondine, then let me have the pleasure to introduce you. Well, Blondine is professor of contemporary history and international relations at the University of Aix-Marseille. She is a distinguished expert of the IRLA and has made significant contributions to the association for the last 20 years. His research focuses on the relationship between legal systems, politics, and religious in France and the United States, and on the impact of the religious factor in international relations. I would like to mention some titles from, she's a very prolific writer. I would like to mention some titles. Catholics and US Politics After the 2016 Elections, Géopolitique de Religion, the chapter France on the forthcoming Oxford Handbook of Religions and Europe, and she has written also about COVID-19, vers la Société Internationale de Risque. Well, now her contribution to this webinar, to this seminar, has to do with a very lately, I would say, timely, the topic we talk about, from shaft to angry attitudes against temporary suspension of public worship in France. Thank you for accepting the invitation, Blandine. Thank you. You have the floor.
Thank you. Do you hear me well?
Yes, perfect.
Yes?
Yes,
Okay.
we do.
Oh, perfect. Dear friends, I would like to present now the religious reaction to the French health or sanitary policy against the spread of COVID-19 as a centralized policy that emanates directly from the government and does not suffer any regional or local organization concerning its management. I will very simply explain how, between the first and the second quarantine, the situation has evolved. Actors and issues have not been the same. The awareness that the freedom of worship has been mistreated or unduly ignored has gradually emerged, both in public opinion, but also by the judiciary. My presentation is divided by two periods of time with a different panorama. I apologize in advance for dealing only with the issue of the worship suspension for lack of time, because there is another question which has been very dramatic and which I'm just now evoking. That's one of the disrespect caused by the sanitary prohibition measures on visits and sick or dying people accompaniment. Disrespect for people's dignity at the end of life, whereas they were sick or not from COVID in medical and old elder care establishments. And second, disrespect for the deceased people's dignity, deprived of religious rituals before and during their burial. One realized that our legal system offered poor relief for relatives when they tried to take legal action, apart from the penalty of non-assistance to a person in danger, which did not feel well with the situation and did not repair distress and inhuman experiences caused by these health measures. This debate will undoubtedly lead to corrective legislations and common guidelines for the future produced by public institutions devoted to human rights, ethics, religious institutions, and associations. I will therefore focus on the other issue, temporary suspension of worship gatherings. Let us begin with the first period, the first state of health emergency, which lasted from March to July with a general population and war quarantine from March to May, then a lightened quarantine from May to June, and then it ends with very strict sanitary measures, not so strict as the epidemic comes back in September, and the right for all establishments welcoming the public to reopen. During this period, the government issues 2 decrees to quarantine and close public locations in March, followed by less strict decrees to reopen them. Their policy was to prohibit religious gatherings. To accomplish this, religious buildings remained open, but the worship and weddings were first reduced to 20 people and then suspended, with one exception, the funerals, which were first accepted with distance measures and then reduced to 20 people. Religious officials initially accepted these restrictions without saying anything. And it should be noted that the Protestant federations, the Jewish Consistory of France, and the Muslim representative organizations did not contest these decrees, nor the others that followed with some alleviation right to the end. The Jewish community, very much affected after the Fest of Purim, communicated through the Representative Council of Jewish Institutions of France to urge people to avoid synagogues attendance and family fests for Pesach and Shavuot. The same attitude was espoused by Muslims who often closed their mosques or incited practitioners to stay at home for the prayers of Ramadan and Eid. Muslims did not celebrate Eid in France by public worship this year. Finally, there were Catholics from militant associations, either right-wing political associations or integrist association, who mobilized in May when, by the first de-quarantine decree on May 11, some establishments devoted to public audience were authorized to reopen, including schools, public services, but not places of worship. They appeared before the Conseil d'État, our highest court of public law. The Conseil ordered the government to review its decree. The general and absolute prohibition of worship gatherings in worship places, though they were possible in other places open to the public, was disproportionate to the objective of public health. The government, therefore, issued a decree on May 23rd, authorizing the coming resuming of public worship, provided great caution. And the Catholic Church said it was satisfied, even though she was not at the origin of the appeal and therefore celebrated Pentecost in its churches. But as I have told you, the other religious denominations did not. They refused to do so, and then they maintained their worship suspension until June 3rd. What is interesting with the Conseil d'État's ordinance was that the Conseil reaffirmed freedom of worship both as a collective gathering for the practice of a religious ritual and as a fundamental and essential freedom. It had done so previously with cases challenging the anti-terrorism laws that expanded the possibility of closing places of worship when terrorism apology, sedition appeal, and incitement to hatred and violence were proved. This assertion, freedom of worship as fundamental and essential freedom, secures this freedom both individually and collectively. Freedom of worship was recognized in the 1905 separation law, but it has never been constitutionally enshrined. It was an opportunity for the Conseil d'État to express its full value, a fundamental and essential freedom. Let us now move on the second period in which we are still in France until December 15, if all goes well, and which will continue if our contamination curve has not fallen sufficiently. The second national state of sanitary emergency has been decided on October 20th by a Prime Minister's decree imposing freedoms restrictions on freedom of movement, of assembly, of shopping, of dining, of exercise, anything, imposing a curfew and a partial population quarantine, lighter than the first one. Schools remained open and people can go to work. The decree decided closure or activity cessation for any establishment that was not essential to economic or social life. Thus, if the grocery stores remained open Other shops and restaurants were not, nor, once again, the places of worship. They were left open, but the public worship was suspended, except for funerals and this time for weddings. Immediately, the Catholic Church protested. Compared to the previous situation, what has remained the same was the very obedient attitude of the other religious denominations in the country. They refused to take part in the legal action brought before the Conseil d'État in early November, as asked for. And Protestants, Jewish, Muslims remained legalist and accepted the terms of the decree. So there were Catholic associations, the same as in May, which initiated the lawsuit, but this time they were followed by 9 bishops and finally by the Episcopal French Conference with disagreements inside it. I suspect that the Episcopal Conference went to court so as not to be doubled by the Catholic activists from private and political associations that seemed to reproach the church in some way, in some extent, its immobility. Online petition of 100,000 signatures for the Mass was sent to the government. And we are not used by these American methods, but it worked. This time, the Conseil d'État rejected the suit, and the decree's limitation on freedom of worship, personal freedom, freedom of movement, and freedom of assembly were not obviously illegal, since the decree gave the right to go to the church for individual prayers, to marry and to be buried, and the right for the clergy to perform the rituals and to broadcast them to their audience. While rejecting the suit, the judge advised the government to urgently consult with religious authorities to further improve facilities. The Conseil d'État ordinance made Catholics angry, and some began kneeling before their churches and cathedrals, asking for mass reopening. A form of public protest began to be relayed on religious intolerance, religious discrimination against Catholics by the state, etc. And the government, which has just whipped an international bronca on French intolerance and Islamophobia, immediately reacted to the Conseil d'État's advice, especially after the Minister of the Interior threatened Catholics who knelt down outside in a period of legal quarantine to be removed and to be paid a fine. And so the minister was blamed and mocked by the press. And so, and that is my last point, throughout November and until yesterday, we observe a series of meetings, discussions, debates between the government and the representatives of the Catholic Church to find more appropriate solutions than worship suspension. And after discussion, the Prime Minister announced that on November 15 that public worship will be authorized under 30 people's assembly. The Catholic Church publicly answered it was unrealistic, and Catholic associations once again complained. The Conseil d'État accepted on November 29th, last Saturday, to judge the restriction of 30 people too strict and disproportionate because it does not consider the size of the religious buildings. Yesterday morning on the radio, the Prime Minister proposed to relax these limits for a security perimeter around each worshipper. And the Minister of the Interior adds after him that it means 2 seats free between each person, except for families which can stay side by side. Okay. And furthermore, the ministry urges the religious authorities to continue the discussion in order to prepare the next measures after December 15th. This morning, our religious denominations had considered this announcement acceptable. I have not heard the Catholic reaction yet, but we can see how cautious the government seems to become and how the freedom of worship was taken more seriously after several months of strict policy. I thank you.
Thank you. Thank you, Blandine. Thank you so much. You end very quickly. Okay. Well, we were waiting for something else. Anyway, well, I would like to mention that, of course, I mean, thank you so much for giving this very flash. It's like a flash about France, okay? Mainly on worship suspension. Well, something that is comes to my mind, because this sort of restriction we have had in Europe, in many other European countries, that I would like you to keep in mind for the question and answer session after that, after this. What about, I mean, if you consider that in France, this worship suspension should be taken or considered as a restriction or as a limitation from a legal point of view. That's my question for the next, for if it's a restriction or it is a limitation. That is something that we have been discussing in many other webinars, okay? Well, now is the time for the question and answer period of time. Then we have here, the first one in the chat comes from Alexis Artur. This is a question for Ibrahim Salama and Michael Winner. It's a very specific question. How does the Four Rights framework define a community of believers? And was that a point of debate in the development of the framework? The issue seems very sensitive, especially with regards to the recommendations to focus critique on one's own community and not criticize other communities. Then I give you the voice, Ibrahim or Michael, whoever, or both of you.
If you don't mind, I start, and then I'm sure Ibrahim will be complementing me. And thanks a lot for this excellent question. And actually, yes, it was quite a long discussion that we had initially already in Beirut when the Faithful Rights Framework was discussed. And there, if you look into commitment number 2, which says that the present Declaration of Faithful Rights is seen by the participants as a common minimum standard for believers, and then in brackets, whether theistic, non-theistic, atheistic or other, based on our conviction that interpretations of religion or belief should add to the level of protection of human dignity that human-made laws provide for, unquote. So here you see already a first element of a definition, obviously linking it back to General Comment 22 of the Human Rights Committee, where this formula of theistic, non-theistic, atheistic, or any other beliefs, which are equally protected by Article 18 of the International Covenant on Civil and Political Rights, is coming from. Then if we go into the toolkit, there again in Module 2, there's a specific explanation also explaining this fundamental shift from each religious group defending its own community against others into the notion of a community of believers. Perhaps that's also what you were picking up. And this community of believers basically defends the rights of all faith communities. And this togetherness, that's what the toolkit stresses, is at the heart of the Faithful Rights Framework. And togetherness and community of believers, regardless of variations of their beliefs, is also then coming a bit later. And then perhaps yet another explanation in the module that we were discussing about ethical and spiritual leverage, 16. There again, this March statement by Religions for Peace on statement on coronavirus crisis. It also uses this terminology, interestingly. As a community of believers from different faith traditions across the globe, putting aside any theological differences, we submit that many of the crises we face are human-made and have been managed neither with fairness nor in solidarity. So I think these are the elements which obviously won't give you a precise definition, but it shows that this has been very much at the center of discussions. And the idea is precisely to go away from this, I'm basically just protecting my community, and it's a zero-sum game. If I don't get this share of attention, money, or whatever, then basically it will be going to someone else. And also this logic of being compartmentalized in silos, that's precisely the idea to overcome this approach. And that's also behind the idea, my last sentence, that you should basically be critical introspectively. So everyone starts first with criticizing themselves, and then ideally coming back better together and joining forces in a human rights-based approach. But I think Ibrahim may have additional points.
Thank you, Michael. Ibrahim, do you want to add something else?
Not much. Michael said it all, except to add probably that this is the major shift and the major contradiction in a way in the religious sphere. On one hand, it's extremely diverse. On the other hand, the interreligiosity is too recent as opposed to the long century history of religions. So this shift into a community of believers based on everybody keeps their own theologies, but where is the common amongst us? It's relatively new and it's extremely promising. Over to you.
Thank you. Thank you so much.
Perhaps I could ask a follow-up question about the question about communities, because this idea of community of believers, yesterday, Louis-Léon Christian talked to us about the recent integration, the recent recognition by Belgium of a form of humanism or a form of laïcité as being one of the recognized religious groups in Belgium. Would that count? Non-theistic forms of belief, would that count within this framework of community of believers?
Absolutely, and it's theistic, non-theistic, atheistic, or any other believer. So literally anyone who is self-identifying as a believer is actually protected by Article 18 of the ICCPR. And I think that's also a key point that oftentimes falls under the carpet. When you think about religious freedom, already the term religious freedom is only basically pinpointing religion. But you have all these non-theistic, atheistic, or other believers who are equally protected. And that's, by the way, also the reason why it's called faith for rights and not religions for rights. Because we looked and discussed for long in Beirut to find also a terminology that the humanists, the atheists, that were part and parcel also of these consultations, that they could self-identify with. And ultimately, I think that was a good terminology and compromise, because the humanists and atheists, they said, all right, I wouldn't identify as a religious believer or religion. That's not my cup of tea. But faith, also from a humanist and atheistic perspective, I self-identify also with that. So I think that's really the key and explanation behind this inclusive approach.
Right. Okay. Thank you so much for the explanation. Is there any other question on the floor? Because I am trying to follow the chat, but I cannot see any other. Is there any other question on the three presentations we have? Well, I'm sorry for Blondines, because there are a pair of questions I would like to ask, but of course the French case is different in Europe. Again, I mean, they are a sort of exception concerning Catholics. Okay. Well, I don't know if there is another question.
I believe Rosa-Maria Blondin will be back in an hour.
Right.
Oh, well, there was a question in the chat, but perhaps we could address this question, and Blondin will be back, and hopefully Alessandro will be back. Maybe we could get some questions for them at the end.
Later on, okay, at the end of the other session.
Question.
There is a comment by Professor Meyer, Jean-Francois Meyer, regarding other types of groups, secularists. A French MP who interviewed me about the impact of COVID-19 on religious groups made an interesting remark that the French Freemason lodges also had to close their doors. It was planned until September, but I do not know if it continues at this point. So this was, and others may know about France, and it was a question that I had asked if early on it seemed only the conservative Catholics were protesting this, And I didn't quite understand, on the second round of closings, did Protestants and Jewish groups also begin to protest or not? And it looks like yes.
Well, Alexis, do you have any idea about this?
Jean-François Mayer wants to intervene. You have to unmute, though.
Oh.
Yes, I just reactivated my mic, sorry. Well, indeed, in the second round, the last one, there was also one Protestant group, obviously from the evangelical milieu, who was on the list of people who complained. But indeed, that was one group compared with the number of Catholic groups associated for submitting request to the Council of State. There was merely one Protestant group. So definitely the difference remains clearly, you know, you don't have any Jewish, any Muslim group and so on, and merely apparently one conservative Protestant group who associated. But probably Blandine would be able to tell us more.
Well,
there's a strong contrast with the case in Germany there, because in Germany, the suspension of bans was motivated by, I believe, a complaint lodged by a Muslim group in Lower Saxony, which went up to the Constitutional Court.
That was originally, that was in the first wave, indeed, yes.
Yeah. And it stands in some contrast. Here in America, it seems most of the cases have been brought by evangelical Protestant groups across the country, though the New York case that the Supreme Court just heard was a combination of Jewish groups and Catholic groups.
But exactly, but don't forget, of course, the context that what happened in spring in France, one of the huge super spreader was actually an evangelical congregation in Eastern France. And so obviously this created a context, because really the backlash for that group was very huge, very heavy. They still feel it. And actually they lost a number of their members who died of COVID, I think 20 of them. But moreover, their public image was a disaster. So obviously I can understand why there is a reluctance of evangelical groups to ask for lifting of restrictions due to that much publicized experience of one evangelical church in February, March.
Nick, do you have records about evangelical Protestants' deaths because of the COVID? Do you have that sort of registration or whatever, or record in US?
Well, not exhaustively. We do know that there have been some super spreader events based on church services that were held without social distancing. And at the beginning of the pandemic, that happened in a few places, and those churches very quickly closed down. I'm particularly interested in the difference between Europe and the United States, because it suggests I had thought that Catholics were more opposed to the closing down, in part because of their more sacramental theology.
Yes.
For Protestant groups, it's less important perhaps to physically meet as a theological matter, but for the Catholics and the Mass and the need for physical presence is much higher. But I have to say, in America, other than the Supreme Court case, mostly Catholic groups have been quieter than Protestant conservative evangelical Protestant groups. And so it surprises me, and I'm not sure what the explanation is.
I think one of the things that Blandine pointed out, it was nice about the politics of this, is there's an ongoing conflict between the French Catholic of bishops and more conservative leaning Catholic groups about the centrality, not about the doctrinal centrality, but perhaps about the cultural centrality of the sacraments. And the Conference of Bishops' reluctance to take on the government in terms of a ban on receiving the sacraments exposed them to stronger internal critiques. And in this last wave, they wanted to head off that critique internally by lodging complaints themselves. And I think that was an interesting part of Blandine's analysis.
In the United States, Nick, you mentioned that you don't see as much pushback from Catholics, but in San Francisco, for example, where indoor church services were barred for quite some time. Actually, I think that only changed in late September. The Archbishop there was very active. There was a lot of communications going on between him and the mayor. There was a Free the Mass Sunday, lots of signatures, and eventually, I think the Department of Justice sent in a letter, but eventually that got the worship services were put more on a par with indoor dining, and so that died down to a great degree. So I think part of the difference with Catholics in the United States is there's not a real pushback unless the restrictions get very severe. Whereas with evangelical groups, there's a broader pushback, even, quibbling with differences that the Catholic leaders wouldn't quibble with. So again, in the case in New York, those were very severe restrictions. So the diocese became involved in that, but there were a lot of other dioceses. I don't know, well, if the one covering Manhattan had hotspots too, but in any event, it was one diocese there, but severe restrictions.
And I would say the issue of contextualization that has been mentioned already is quite obvious. We can make a comparison between France and the French-speaking areas of Switzerland. In several areas, French-speaking areas of Switzerland, there has also been the limitation to 30 people attendance. And you had no people kneeling in front of churches. Of course, you had people commenting, it's ridiculous. Obviously, there is more space in a cathedral. You cannot apply the same rules to a cathedral or a small chapel, but you had no kind of public demonstration, no people kneeling in front of churches, no people submitting requests to courts and so on, just because there is a different general context relating probably to the way measures are perceived. And obviously in France, due to the context, it's very easy for French Catholic activists to perceive measures as being something against religion, while obviously this wouldn't be the case in Switzerland, different context, even if those are exactly the same measures.
If I may just add, obviously you have these cases where religious communities feel themselves targeted or are actually in a worse situation than shops or other entities in that sense. But you also have the other way around, basically preferential treatment to places of worship. And just to flag something which over which I stumbled in The Guardian, for example, there's a tequila bar in Nottingham that plans to basically get around tier 3 by registering itself as the Church of 400 Rabbits, basically, and claiming it's a place of worship. Because with this place of worship, it would have less rigid conditions to reopen its tequila bar. So I think just this now sounds obviously hilarious, but I think it points the finger that it's important to be non-discriminatory and not have arbitrary criteria built in or having different measures targeting different communities differently.
Your point is highlighted here in Michigan. The state of Michigan has had some of the most extreme closing measures in the country, a lot of opposition to our governor here. We have a very mixed state, strongly conservative and strongly democratic. But from the very beginning, she has entirely exempted worship services of any kind from any of the restrictions. And so most churches have voluntarily complied, either shutting down entirely or implementing the distance guidelines. And so there are several states which perhaps provide an interesting example where if you do not regulate, if you choose not to regulate the religious groups, by and large, our experiences here, they're mostly acting pretty responsibly, and we're avoiding any major outbreaks, at least here in Michigan.
There's a specific thing in France. I don't know how it's formulated in the US or in other European countries. So the decrees on bans on public gatherings need to specifically mention what are called establishments of the cult under Section 5, because those are governed under a specific form of legislation from the law of 1905. So I wonder if that also increases a certain amount of tension, because there's a specific targeting within French law, but that just derives from the organization of church and state in France.
Yeah.
Brett.
Is there any other question coming from the floor?
Yeah, thanks. Rose, is it okay if I ask my question?
Yes, please.
So we've been using this term super spreader event and talking about the bad publicity that's happened for churches that have been the locale for super spreader events. One thing I've been interested in is sort of the differential treatment between large outbreaks that happen in religious settings and secular settings. It seems that there has been a different sort of reaction to sort of major breakouts that come from an academic conference or from a bar or restaurant versus a religious community. I'm interested, Jean-Francois, in your perspective on this, but also maybe your Alexi and Ibrahim, and also yours, Michael, from Europe. Have you detected a sort of a difference in sort of, maybe I'm thinking mostly about press coverage, press coverage and public reaction to sort of maybe equivalent scale events, but those that happen in a religious context versus other contexts?
I would definitely agree on that point. We know, of course, that one of the first major outbreaks, super spreaders, were, for instance, soccer competitions in Italy. Then you had a number of winter sports resorts where people would meet in bars and so on in the evening, and that has played a major role. Of course, it has been publicized, it has been commented in the media, but it has definitely not led to the kind of hate reactions that some churches, such as La Porte Ouverte in Mulhouse, have really experienced. They were really even nearly afraid of gathering again, because as soon as just 10 people would come to the church for recording the Sunday service that would be streamed online, you would have people phoning, those crazy people are starting again to have public worship and so on. It's obviously linked to the perception of what those groups are. I wonder how far, for instance, a similar event in a Catholic setting would have given rise to similar reactions. To some extent, possibly, but not as much. Don't forget, there have been the cult wars in France, and quite often evangelical groups in public perception have been associated to kinds of cults, and you know, even if they now make a large percentage of the French Protestant Federation, because a large number of evangelicals are now members, belong to the mainstream Protestant organization, still there has been quite often a perception of them, you know, as strange radical groups, religiously radical, of course, not in the same way it's applied to Muslims, but definitely I think this has played a role. And I think we could have, and I hope some French academics will engage into a case study on the reaction against La Porte Ouverte in Mulhouse, because this will provide a perfect, just going through all the media reports about it, and especially, okay, the way it was presented, because some media made the efforts also of contacting, giving really different viewpoints. And then you see that actually the people of La Porte Ouverte, as soon as they realized what had happened, they communicated with health authorities in a very responsible way. Actually, I understand that the son of the leading minister is himself a medical doctor, so he was completely aware of what was happening, and really they acted in a very responsible way as soon as it was obvious. But still, image was a kind of enthusiastic religious group gathering and so on. And it was even more shocking, those kind of reactions, because when they had that huge gathering, it was at a time when no gatherings were banned in France. It was still late February. So definitely, if we take that case, there is no doubt it has been much more publicized than any kind of secular event. And this shows once again the need to put that into context, definitely.
There's a certain hypocrisy here in America where every weekend we have major NFL and college football games, right? And there's dozens of players on each sideline, and there's occasionally outbreaks. And the press, you know, there's not an outrage to it, but you can't gather in worship in a cathedral with more than 10 people, or it's the end of the world. So there's your point is a good one, Brett.
I just wanted to also confirm Jean-François Meyer's point that there may be really a different treatment for minority communities, where obviously, and as Brett was obviously implying, this is much more interesting for the media to look into. And for example, the South Korean case, if it had been one of the whatever the Catholic Church, it would not have attracted the same attention. And just one interesting part, because in our hypothetical case scenario in the Faith Rights Toolkit, we also embedded obviously this element, but then also from a religious freedom perspective, something I think quite interesting. So in the case, we said that the religious leader said that they strongly opposed any vaccination because this would alter the body's blood system, which is considered sacred by the Holy Scripture of this hypothetical religion. Obviously, it's mirroring some communities' approach. But I was struck when we did the peer-to-peer learning. Many of the civil servants immediately basically went and said, oh, but they're not allowed to think or to believe in that. And I think it was really a good learning curve for the participants to then look into what is freedom of religion or belief entitling, and where are the limits? What are the limits to the limitations? So I think these hypothetical cases, which have all these elements of real life cases, can be really useful to discuss in a also not confrontational manner, because then it's Jehovah's Witnesses. But here it's basically a religion, which diffuses the tensions and lets the participants focus on the substance.
Thank you, Michael. Thank you for your own opinion about it. It's quite important. The relationship between majorities and minority groups, of course, and the different treatment in the press, in the media. Yes. Well, is there any other question left? Because we are arriving at the end of the session.
Yeah.
Yes.
Rosa Maria, I would just say, Alessandro, we got him a number, but he doesn't seem to be able to get back online. Maybe he can join us next session. I'd just like to ask people to keep your connections open. You can mute yourself and turn your camera off so we don't have to bring you all back, but we'll start the next session at noon our time, 9 o'clock on the West Coast, and I think it's 6 o'clock your time, Rosa Maria?
Yes, I think we have then 30 minutes break as it was planned.
Exactly.
Yeah.
Yes.
Thank you so much to all the audience. Thank you for your collaboration, contributions, and for opening new understanding of COVID-19. Thank you.
Thank you, everyone. We'll see you in half an hour for the North American panel led by Brett Scharfs.
All right, well, welcome everyone. My name is Brett Scharfs. I'm the director of the International Center of Law and Religion Studies at Brigham Young University. And I'd like to express my gratitude to Nicholas and Alexi and Rosa and others who've been involved in helping organize this event. As I said yesterday, I think this is really sort of modeling new and innovative, very creative ways of working in the difficult situations we have. Both the opportunity to listen to each other and to be learning from each other's experiences, I think our experiences with COVID are remarkably varied from place to place, and over the course of time, the infections have varied in their severity, but the political and religious implications have also varied significantly. And I think it's wonderful for us to have the opportunity to, post our thinking online on our various web pages and blogs. And then also, again, I express our appreciation to Ganoon Diop and IRLA for devoting an issue of his journal to our work. And so I think it's an opportunity for us to try to affect the global conversation in ways that are sort of scholarly, less fraught with sort of panic and emotion than some of the coverage, and less politicized, frankly, than a lot of the media coverage that we see. So I'm appreciative to everyone who's participating, and I'm grateful for the opportunity I have to sort of learn in real time about what you're thinking about from your respective perspectives on this topic. We're going to begin with Alessandro Ferrari, whose connection has been reestablished. We're grateful that you were able to go out and restart the electrical grid, Alessandro, over the last 30 minutes. So congratulations for that. And you were in the middle of sort of talking about the situation in Italy. Why don't you go ahead and give a brief recap of what you had covered so far, and then go ahead and finish your presentation.
Yes,
and then
yes.
After you've done that, I'll have a few introductory remarks for the US panel.
Okay. So the focus of my intervention at the beginning was that the debate in Italy about COVID-19 and its consequences on religious freedom was based most on the two dimensions of the religious freedom. So on the fact that on one side, we clearly see it has a constitutional fundamental right, but the state of emergency, this situation revealed also the institutional side of this right. So the fact that is connected to different legal orders, this dimension that is connected to the double or more sovereignty of state and religious order. This is very typical, this double character of the right to religious freedom in the Italian legal system, because obviously of the presence of Catholic Church and how our constitution reflect this right. So the COVID-19 experience has been very explanatory of the tension between these two different ways through which you can see the same right to religious freedom, from a perspective, a constitutional right oriented perspective, or a perspective more devoted to institutional relations between legal orders. I try to explain this. As I was saying before the electricity cut, everything has beginning when the government has declared the state of emergency at the end of January of this year, following the civil protection code, the civil protection code. And thanks to this state of emergency, several fundamental rights have been limited. I say the right to circulation, to conduct a business, cultural rights, the right to education, and obviously also the religious right was affected, as in other countries, in what are the more public and collective dimension connected to gathering. In this way, as in other countries, Italy has followed a sort of comparison between secular and religious gathering. So public ceremonies have been suspended, but differently than cinema and theater that were closed, churches were never closed. So churches were open. It was possible to go in the church, but was not possible to have public ceremonies. And so I think that was an attempt to balance the situation. But the debate was more about the state of necessity, because the state, of emergency was not dependent on a fact of necessity, but was connected to a specific law, and so was something that our constitution, although indirectly, allow. And on the other hand, the limitation of the right to religious freedom was the product of a balance between the right to religious freedom with other rights, for example, the right to health. Religious group accepted usually quite well this situation. The Catholic Church was quite supportive. Muslim communities very supportive. In general, were not a problem. But immediately, one thing was a little disturbing for religion, because even President Macron in the separatist France phone religious group before taking its measures, but in Italy, the government started limiting the religious freedom unilaterally without any consultation with religious group. And this is quite exceptional in a country that is very used to contractualize this right. And this fact, this unilateral way through which the government decided to intervene in relation to the right to religious freedom was at the beginning of a tension that was growing above all among ecclesiastical lawyers, not among Catholic churches or religious groups at the beginning. And it's interesting, the doctrinal debate, I will say, about this limitation, because this debate revealed two things. On one side, the resilience of what I call the exceptional right. So some authors claim the fact that the right to religious freedom is not like the other. It can be balanced with other rights so easily. And in this debate, was very easily to forget the comparison with a secular gathering, and also a sort of preference accorded to religious freedom in comparison to other rights, because I repeat, churches were never closed, but the comparison was always with business gathering. And so was the famous and offensive in some way idea that it was easier and freer to go buying cigarette than to go to prayer in the church. And this was not very exact, but this gives the idea on how were perceived this limitation. On the other side, the unilateral character of the limitation was also a problem, because for some doctrine, some lawyers, in the debate, the state of emergency was not connected to the state of emergency provided for the Civil Protection Code, but was just justified in the name of the force majeure. So it was justified in the name of something that is out from the positive legal system. And this approach that transformed the necessity as the direct source of the state of emergency was used to show how the state of emergency clashed with constitution, and in particular with the Article 7 of the Italian Constitution that protect concordat. So the idea that the state of emergency had not a constitutional foundation, and for this reason was against the concordat that obliged the state to contractualize, to decide with the Catholic Church and maybe with other church with agreement with the state limitation. This is an interpretation that in my way is not totally convincing, but above all is not convincing for the consequences that this interpretation, if accepted, would have, because the consequences, it will be that only toward religious without bilateral agreement, the limitation would have effect. And this is not coherent with the integrated constitutional right to religious freedom that in relation to the fundamental part doesn't allow differentiation among religions. But anyway, this fact that the debate was all about the concordat and the agreements between state and religions move the debate, the legal Italian debate, from another perspective. Nobody or very few people interrogate themselves about the use of, for example, of the Article 15 of the European Convention about the suspension of fundamental rights. And so the right to religious freedom was not seen in the frame of the multi-level protection of fundamental right, but was seen in the light of the legal distinct order. So was seen in the frame of the relations between the state and the Catholic Church, above all, and other religious order. And this reveals a sort of a fragmented right that is not completely conceived as the other fundamental rights. And this is also against what the Italian Constitutional Court has done so far in interpreting this right. But this debate has had important effect, because very soon the pressure on the government to contractualize the limitations, so to transform the unilateral intervention of the state in bilateral agreement with religions, became very strong. And at some point, there is a breach in the legal construction provided by the state, in particular at the end of March, when the Ministry of Interior made a note, a sort of circular, when it allowed more participation in the mass, so allowed some people to participate in the ceremony that were allowed in churches. And the mistake was there in the fact that in this note, the Home Ministry used canonical word. So he allowed the fact that in this mass could participate deacons, cantors, readers. The Home Ministry used liturgical words. And this fact that the Home Ministry, in answering to the Italian bishop, use words exactly that are from the canon law legal system, push the interpreter to say that the Home Minister was not allowed to use internal words without a formal consultation of the other legal order. In this case, this note was at the beginning of beginning of a new regulation. And this new regulation was connected to the passage from the first to the second phase. When the wave of the epidemic started decreasing at near March, May, the ceremonies started being allowed. But what is interesting is that this second phase is characterized by a new approach of the government, because the government at some point started—
2 minutes, okay? 2 more minutes.
Yes, started to sign protocols, and started with on protocol of May 17 with the Catholic Church, and this protocol was followed by other 6 protocols, protocols that gathered together different religious community. 1 protocol for Jewish, 1 for Protestant, Evangelical, and Anglican, 1 for Orthodox, 1 for Hindus, Buddhists, Baha'i, Sikh, 1 for Islamic communities, 1 for the Churches of Jesus Christ and Latter-day Saints. And 1 protocol was approved by the government, but not signed by the Jehovah's Witnesses. What is interesting in my way looking at this protocol, that only the protocol signed with the Catholic Church was written by the Catholic Church. The other are written by the Home Ministry with the participation of religious groups. But in this protocol, there are full of very precise liturgical norms that maybe is not the case to put in an agreement with the state, that they should maybe stay in proper own law just made by religious group. And it's interesting that this bilateralization is quite forced. We look at the protocol signed with the Latter-day Saints, because in this protocol, there is an Article 10 that is very interesting, that I want just to quote to you. In this protocol, we read, in relation to particular aspect of the cult, which may involve close contact, the competent religious authorities are entrusted with the responsibility of identifying, for each confession, the most appropriate forms, to maintain the necessary precaution to exclude any risk of contagion and transmission of the virus. Why is this interesting, this norm? Because it reveals that this is a very general norm that could be used in relation to all religious groups, but it has been contractualized because the state was not able to write just by itself this rule, because it had to show this bilateralization. But in reality, this kind to write protocols in some way has trivialized the concordat, because in fact this protocol became more a sign of jurisdictionalism, and so approval from government to very specific liturgical norms, instead to continues, as Spain, for example, has done in preparing general norms by the state that religious groups can apply following their specific situation. And this also revealed the fact that in Italy, this kind of contractualization can be used in relation to all the group, gathered together in religious families, groups that maybe are not really being convinced, or they even don't know to participate to this kind of groups. And this is a sort of pathology, I think, of the concordatarian system. And so a lack of a general legislation in matters of religious freedom able to offer a more broader picture in which only very real specificity has to take place. But this revealed the tension between a right conceived as a constitutional fundamental right and a right that is still very thought in relation to interordinamental relations. And I think that this protocol that has so emphasized, in reality, they are describing a crisis of the concordatarian system more than its revitalization. I will stop here because there are too many things.
All right, thank you so much. I'm glad we were able to reestablish the connection with you, Alessandro. And I hope you'll be able to stay with us for the question and answers. It's clear that there's some really interesting and distinctive characteristics of the Italian response, and especially in the institutional relationships between religious groups and the government. And it really does grow out of that concordat system and then the analogous agreements that have been made with other groups as well. I'm going to forego my preliminary remarks in the interest of making sure that our speakers all have a full measure of time. Our first speaker is Professor Cole Durham, my senior partner and friend, the founding director of the International Center for Law and Religion Studies here at Brigham Young University. He's currently the president of the G20 Interfaith Forum and is going to be sharing with us some remarks today. I think in some ways, really complementing the presentation of Professor Corbin that was focusing on the general and neutral test, Professor Brady, who was really focusing on church autonomy. And I think Cole is going to focus on those issues, but as well, the compelling state interest test. So Cole, let me give the floor to you.
Okay, thank you very much, Brett, and apologies that I couldn't be here this morning earlier. We had the handover from Saudi Arabia to Italy of the G20 Interfaith Forum this morning, and I had to be at that event. But it's good to be back here. Experience with COVID-19 has refocused attention on the relationship between the state's interest in protecting public health and the protection of freedom of religion, even during a clear health emergency. Does the state have unfettered discretion to shut down religious services? Can the state regulate clergy conduct in ways that preclude the administration of last rites? Can the state specify whether and how religious rituals are performed? Can the state dictate funeral practices? Is the state free to determine how essential religious practices are? On the other hand, can a religious community wear out its welcome by making religious liberty claims where this contributes to a social perception that the group is making a selfish claim without caring about implications for others? To what extent does a religious group, simply because it has religious needs, have the right to put others in the community at risk? We clearly understand situations where we believe that conscientious objection deserves to be respected, even though risks, even risks of life, are imposed on others. Conscientious objection to conscription is the obvious case, though even there, expectations of alternative service are generally understood. How strong should the presumption in favor of freedom of conscience be? What if the religious community is in fact rendering all kinds of service, but this is not generally known? Bad news travels faster than good news about sacrifices that religious communities make. News about all that religious groups are doing to help minimize spread, finding alternative ways of meeting, providing service to the sick and vulnerable, and so forth, are all much better in promoting appreciation of religious concerns than mere assertion of religious freedom claims. But of course, how each religious community responds is itself an internal matter. Now, these are simply a few of countless issues that have arisen over the past several months. The challenge presented by such examples is complicated by the fact that different religious communities have different religious practices, generating distinctive religious needs and posing distinctive health risks. Also, for a variety of internal religious reasons, different religious communities may have differing abilities to adapt their religious practices to publicly imposed mandates. So that's the problem. One answer to these and many other religious liberty claims arising in the pandemic context is simply to hold with the Supreme Court in Employment Division versus Smith that so long as the health policy is neutral in general, it prevails. Caroline Corbin gave us a fairly thorough analysis yesterday of how this approach comes out. In the absence of blatant discriminatory targeting, applying this approach will almost inevitably sustain implementation of the state's policy. But that, from the standpoint of most believers at any rate, tilts the balance too far in the direction of the state. At this point, in the United States, fortunately from my perspective, a majority of jurisdictions, either by statute or by judicial decision interpreting state constitutional law, have rejected that approach and insisted on a second alternative, an insistence that some form of heightened scrutiny is required to justify imposing a substantial burden on free exercise of religion. It's been striking that only a handful of state jurisdictions have followed the Smith precedent. And as intimated yesterday, there's some possibility that the current Supreme Court may overturn Smith, at least if Justice Barrett is somewhat less of a Scalia devotee than some might think. I've had people ask me whether, because she was so close to Scalia, would she not dare to overrule Smith? We'll see. Even without a judicial reversal of Smith, the general pattern was set by the Religious Freedom Restoration Act, which sought to restore the strict scrutiny approach of pre-Smith case law, according to which substantial burdens could be imposed on exercise of religion only if doing so is, quote, is in the furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling interest. State RFRA provisions generally echo this language. And of course, since the public health concerns raised in the COVID-19 situation are clearly compelling, the main residual question is whether the health-backed state mandates are narrowly tailored, and that was all discussed yesterday. That narrow tailoring issue is a closer question, but may often be resolved in favor of the state. But the larger point I am making is that there are considerations in the current crisis in which judicial mechanisms for addressing the issues in question break down. So even though health is an obvious and long recognized basis for overriding religious freedom, the reasoning is not easy, and I think my main point in a way is that it should not be automatic. It's analogous in some ways to the dilemma encountered in mandatory disclosure of child abuse. It's difficult to imagine something more compelling than protecting children in those settings, yet we are troubled by compelling priests to violate the seal of the confessional. So you have a religious claim, a compelling state interest, and yet even though there's a compelling state interest, you think that there are situations where the religious claim should win. While strict scrutiny analysis makes it less likely that public officials will simply ride roughshod over the relevant religious claims, there are problems with this approach. It remains at core a balancing approach, and with this in mind, it's worth remembering that it is not obvious that public health concerns are always so compelling that they will automatically outweigh religious freedom concerns. The assumption that public health issues will clearly override countervailing religious concerns overlooks the fact that as public health worries intensify, the significance of religion in people's lives also intensifies. It's no accident that in international law, religious freedom is one of the rights that is non-derogable even in times of emergency. Indeed, it is often precisely in times of emergency that religion is most essential. This reality unravels some of the abstract assumptions, that is the assumption that health concerns always outweigh religious concerns, on which strict scrutiny analysis is predicated. One of the difficulties with compelling state interest analysis is that it sometimes assumes that just because an interest such as health is compelling, it automatically overrides the religious interest on the other side. In fact, the fact that an interest is compelling, however, does not automatically mean it is sufficiently compelling. Abstract assumptions may be unraveled by concrete realities. Moreover, even leaving aside the problem of parallel intensification of interests being balanced, strict scrutiny remains far too blunt an instrument to resolve in sensitive and sensible ways the full array of religious liberty claims that have been highlighted by the coronavirus. On the one hand, compelling state interest analysis may assume too easily that public health interests are so compelling that they automatically outweigh countervailing concerns. On the other hand, while examining less restrictive alternatives obviously helps, this aspect of strict scrutiny spawns fears among some of an unadministrable Pandora's box of infinitely varied possibilities that legitimizes too many alternatives and or allows each religion to become a law unto itself. The worry is that religious claimants can endlessly dream up less restrictive alternatives to the point that consideration of the possible alternatives becomes too costly from the standpoint of the state official administering the alternatives, or questions surface about whether proliferation of alternatives undercuts fundamental equality norms. Something like this is what Winfried Spalding-Sullivan has taken as the proof of the impossibility of religious freedom. But that's a proof that I think unravels as a kind of reductio ad absurdum. I mean, the fact that it's difficult does not mean that we should abandon the right. So in short, the coronavirus poses not only a first order crisis for public health, that is the health crisis of the pandemic itself, but it also triggers a second order challenge for the analytic tools we use to address the religious freedom issues arising from the first order crisis. Now, an initial response to this problem is to shift from the strict scrutiny formula embodied in RFRA to a more direct analysis of equality norms that the strict scrutiny formula were first invented to protect. The equality approach is developed in considerable detail in the opinions of Justices Alito and Kavanaugh in the decisions of Calvary Chapel last summer, and more recently in the opinions of Justices Kavanaugh and Gorsuch in the decision earlier this week in Roman Catholic Diocese of Brooklyn versus Cuomo. Essentially, the justices argued that a careful application of equalitarian analysis arising under various constitutional norms compels the conclusion that religious communities should not be treated less favorably than other types of organizations that pose similar or worse COVID infection risks. These approaches have the advantage that they deploy attractive egalitarian norms and provide concrete reference points that can facilitate neutral judicial analysis. However, as the outcome in Calvary Chapel last summer indicates, the refined egalitarian analysis can be outweighed and swamped by concerns of the state's health interests. Moreover, the concrete comparison points leave room for some arbitrariness in how they're picked out. That is, when assessing whether religious communities are treated fairly by restrictions motivated by reducing spread, should religious worship facilities be compared with grocery stores, with theaters, with schools? And what is the characteristic for assessing the comparability? Is it the likelihood that the virus will spread? That's what Carolina sort of stressed yesterday. Is it a more general assessment of how essential the respective activities are? How does one compare various strategies for limiting spread that the religious communities on the one hand advance with what the state officials advance? And should there be some kind of dialogue? Is there a kind of presumption in favor of the state's analysis or in favor of religious analysis? How does that work? How does one account for the fact that different things may seem essential to different people? In a larger sense, the exclusive focus on egalitarian comparisons risks reducing religious liberty to a mere equality norm. While equality is a vital issue not to be overlooked, religious freedom is about more than equality alone. Now, without disparaging the force and relevance of the equality analysis that is emerging, I believe it's vital to take into account autonomy of religious communities as well. There are, of course, limits to collective religious freedom rights of religious communities, just as there are limits to the conscientious rights of individuals. To cite the most obvious examples, religious communities do not have a right to limit the voluntary exit of their members from their communities. Analysis of this issue becomes complex as one takes into account more subtle pressures that religious communities might use to discourage exit. Also, there are limits on the extent to which religious communities can impose the costs associated with their beliefs on third parties. In general, religious autonomy rights are not so strong that they justify or excuse a religious community in threatening the lives of others, obviously. But contrary to what my colleague Fred Geddix has argued, it's not enough to simply assess whether some third-party effects, some externalities flow to others. Creative minds can almost always identify third-party effects, but reasonable rules allow higher levels of reciprocity. For example, alternative service in draft situations. These can be used to buttress conscientious claims. Both of these limitations raise complex baseline and boundary issues, and those are no doubt going to get worked out as we try to see the scope of what religious autonomy cases should be. But what authorities wrestling with COVID-19 have too often left out of the account is the importance of deferring within broad limits to decisions and judgments made within religious communities. This includes, but is more than, recognizing reasonable alternatives that groups propose as alternatives to regulations. It does not necessarily require that public officials agree with the religious community's beliefs and viewpoints, but it does require respecting the rights of the community to have its own views and distinctive beliefs, which can be acted on or rejected by its members. It requires good faith dialogue and a genuine commitment to finding a way to allow the community to live out its belief, even if there are no obvious comparators. It requires state officials to give considerable deference to what the community regards as an essential service, and a recognition that the state does not have unlimited authority to define or assess the balance of harms. It requires assuring the religious communities are not unfairly stereotyped or treated with disrespect. There may well be cases in which, in the end, the religious community's preference must give way to deeper community needs, but it's vital that the community have the sense that its concerns have been heard and respected, and that there has been a good faith effort to accommodate, and neither the community nor state officials can identify a way to respect the community's autonomy. Deference in the forms I have mentioned. Yeah.
Could you wrap up?
Yeah, okay, let me just see. Deference in the forms I've mentioned here lies at the core of notions of deference that are in the religious autonomy doctrine. I mean, briefly, I have more on this, but I think it's important to understand that religious autonomy doctrine is more than just a footnote on personnel decisions. It's a much broader and older doctrine. And I think we will see that spelled out in various ways. I think the other thing that, and that's clearly going on in the cases, I think one of the worries in this area is that something like the Title VII exemptions, which do cover a broader range of employees, might get whittled away. That would sort of undo the experience that led to those exemptions being created in the first place. And I think also, as we work on this, we need to think about what the Germans call practical concordance, finding ways that where there are sort of conflicting interests, as is often the case, that we try to maximize the extent to which interests of both sides are optimized. So I think that is one of the important dimensions of COVID-19 is to really remind us how important it is to care about the autonomy of the religious groups themselves. Thanks.
All right, thank you very much, Cole. Next up, we have Jeffrey Hammond and Michael DeBoer, Associate Professors of Law at Faulkner University, the Thomas Good Jones School of Law in Montgomery, Alabama. They are each experts in both law and religion and health law, as well as other subjects. And they will be talking about the intersections and conflicts between religious liberty and the new public health. So, gentlemen, floor is yours.
Okay, we have not tested the sound. Are we coming through well?
Yes, it's good.
Yes, okay, thank you. Our paper examines conflicts between religious liberty and the new public health that have arisen in the United States during the COVID-19 pandemic. And it argues that the strict scrutiny standard, rather than the rational basis standard or a comparable standard, is the appropriate standard to protect religious liberty from infringement during the current public health crisis. The design reflected in state constitutions assumes that conflicts between religious liberty and public health measures will arise. While these constitutions recognize that governments must secure the rights and liberties of the people, including religious liberty, they declare that governments exist for the peace, safety, and well-being of the people. State governments thus possess the police power, the authority to provide for common goods, such as public health. Consequently, the government efforts to promote the public's health will generate conflicts with the rights and liberties of the people. In Jacobson versus Massachusetts, the court considered Mr. Jacobson's challenge to the Massachusetts law that authorized municipalities to mandate smallpox vaccinations. When the city of Cambridge acted under this statutory authority and required adults to be vaccinated, Jacobson refused and was fined. He argued that Massachusetts law violated liberty secured by the Constitution. The Supreme Court disagreed, determining that the local ordinance was a reasonable exercise of police power and that Jacobson's liberty was subjected to reasonable restraint for the common good. The size of governments in the United States grew over the ensuing century following the Jacobson decision, and government now reaches into nearly every facet of life and society. This is evident in the proliferation of federal, state, and local administrative agencies that distribute benefits and regulate activities affecting the public's health. During much of the 20th century, the mission of public health was focused upon the control and prevention of disease and injury. And efforts of public health authorities led to many significant achievements, including effective vaccinations, safer foods and vehicles, fluoridated drinking water, cleaner air and water, and safer workplaces. Conflicts between public health and religious liberty were limited and readily accommodated. For instance, many jurisdictions granted religious and philosophical exemptions to mandatory vaccinations to accommodate conscience concerns. Over the past few decades, however, public health advocates have sought to expand the scope of public health. The new public health points to various personal, social, economic, and environmental factors, and it urges that the reach of public health includes addressing these determinants of health by combating poverty, expanding educational and economic opportunities, ameliorating racial and gender inequalities, and confronting crime, violence, and social disorder. These advocates resist the core ideals of classical liberalism and emphasize instead collective interests, social accountability, and government intervention. And even as they pit the public's health against individuals and her rights, including religious liberty, they contend that science and the public good support the expanded reach of public health and their more robust undertaking. In significant measure, the responses of federal, state, and local governments in the United States to the pandemic fit within the traditional understanding of the scope of the public health enterprise. However, in the midst of this pandemic, proponents of the broader scope are advocating a range of initiatives consistent with that broader scope. Protecting religious freedom is not a great concern for them. In their advocacy on other public health matters, the proponents of the new public health have urged that the rational basis standard of Jacobson should apply, and they vigorously oppose the application of strict standards in evaluating public health measures.
In the context of this pandemic, government power now brings religious liberty into conflict with public health once again, but now on a much greater scale. The public health cause, propped up by vacillating and even conflicting scientific opinions and fueled by fears and politics, has in many instances overwhelmed the liberties of religious believers and institutions. With great deference and respect, believers and religious bodies have largely complied with government intervention through mandated closures and conditions imposed to reopen services, even though these closures and conditions have restrained the free exercise of religion. Indoor services and even outdoor services have been prohibited. When permitted to meet indoors, occupancy has been limited, masks and social distancing have been required, singing has been banned, and government agents have been present to monitor. These conflicts have spawned litigation throughout the United States, and various claims have been raised under federal and state law. In several federal cases, claims have been raised under the First Amendment to the United States Constitution and the Federal Religious Freedom Restoration Act. The First Amendment bars federal, state, and local governments from prohibiting the free exercise of religion. Because the Supreme Court's decision in Employment Division versus Smith permits state and local governments to apply neutral laws of general applicability that burden free exercise of religion, First Amendment challenges to these public health measures have focused on unequal treatment and targeting of religion based upon regulations that allowed some businesses to operate and some public gatherings to occur, while churches have been restricted from doing the same. The United States Supreme Court has taken up 3 cases since the beginning of the summer, all dealing with state restrictions on worship during the pandemic. In 2 of the 3 cases, the court denied the church's applications to enjoin restrictions on worship. In the 3rd case, the court granted injunctions in favor of a New York Catholic diocese and an Orthodox Jewish synagogue. As the summer turned into fall, the court seemed to awaken from a posture of wooden deference to state public health officials to a more enlightened awareness that the interest of religiously scrupulous people to worship as they see fit can coexist with health and safety measures. In the first case, South Bay United Pentecostal Church versus Newsom, Chief Justice Roberts argued that California runs a small risk of offending the Free Exercise Clause because, in essence, it treated like matters alike. Its restrictions on the number of people who can come to a church or other house of worship is the same as the restrictions upon other gatherings where people congregate in close quarters for an extended time, like lectures or concerts. He further argued that greater deference should be granted to executive officials who must nimbly respond to changing conditions on the ground and to the changing revelations of science in their attempt to keep people safe. For Roberts, the bottom line was that changing facts, i.e. changing infection and death rates, plus changing science, i.e. how the virus spreads and its virulency, equals the widest possible berth in favor of executive officials, especially when an injunction is sought at a preliminary stage of litigation. Instead of classifying California's regulations on churches under the Smith standard, Justice Kavanaugh in dissent invoked the strict scrutiny standard found in Lukumi Babalu I for laws that purport to discriminate against religious exercise. Kavanaugh did not deny that California has a compelling interest in keeping its citizens safe from COVID-19. Rather, he argued that the state must prove keeping houses of worship under a tight occupancy limit is compelling when compared with businesses that have no such limit. He concluded there is no such compelling interest to disfavor religion when restaurants, factories, and offices can be opened with no limits as to the number of people who can come inside. And I will note in parentheses that I just got a notice on my phone from the Los Angeles Times that the Supreme Court has handed down a mandate this morning telling California to take a harder look at the restrictions they have posed on houses of worship. In Calvary Chapel versus Sisolak, Nevada treated worship services far less favorably than other secular places like casinos or bowling alleys, where more people would be packed together in tighter spaces than in churches. According to Kavanaugh, quote, the government must articulate a sufficient justification for treating some secular organizations or individuals more favorably than religious organizations or officials. Kavanaugh was not persuaded by Nevada's proffered reasons. One, that the public health would be benefited by having different occupancy limits at gyms and casinos, for example, rather than churches, when the public health measures endorsed and mandated by public health experts, like consistent physical distancing, likely would not be respected in the secular settings. And two, that keeping businesses open so that its economy, Nevada's economy, would not collapse was a good enough reason for businesses to have far higher occupancy limits than churches. Calvary Chapel was noteworthy for two reasons. First, it highlighted the hypocrisy of allowing some secular establishments that inconsistently observed mitigation measures to remain open with higher occupancy limits while prohibiting Calvary Chapel from meeting while strictly observing mask and distancing protocols. Second, the case underscored the time element. Both Justices Alito and Kavanaugh noted that 4 months into the pandemic, when Nevada hit the churches with restrictive occupancy limits, the state was still struggling to craft restrictions. Thus, for Alito and Kavanaugh, 4 months had given Nevada ample time to calibrate its restrictions. But for Chief Justice Roberts, the passage of time would not restrict the government's free hand. Finally, in Roman Catholic Diocese of Brooklyn versus Cuomo, the court showed greater respect for religious freedom, no doubt in part because a justice had been added to the court. More noteworthy than the per curiam opinion granting the request for injunctive relief is Justice Gorsuch's concurrence, in which he took issue with the court's precedent in Jacobson versus Massachusetts as controlling in these cases. First, Gorsuch maintained that Jacobson stood for the propositions that courts do not, quote, depart from normal legal rules during a pandemic. Thus, because the application for an injunction by the Diocese of Brooklyn can be classified as a First Amendment case, strict scrutiny must be applied. This is important because it is hard for the government to assert a compelling interest and narrowly tailor the means to accomplish that interest. Second, Gorsuch questioned whether the government's invocation of a substantive due process case helps the government. In essence, Gorsuch suggested that the First Amendment right to freely practice religion trumps the government's restriction on bodily integrity, at least during the pandemic. Finally, Gorsuch noted that the vaccination law in Jacobson had wide opt-outs and exemptions that made the intrusion upon bodily integrity mild. Mr. Jacobson could, for example, pay a $5 fine rather than receive the smallpox vaccination. Gorsuch observed that such generous exemptions might mean that the statutory scheme in turn-of-century Massachusetts would have survived strict scrutiny analysis if that construct were in the law at the time when the case was decided. In New York's restrictive order, however, Gorsuch saw no comparable exemption scheme. No worship was permitted outside the draconian limits if the church or the synagogue was in a red or orange zone. In another federal case heard in a lower court, a church challenged restrictions imposed by Mayor Muriel Bowser in the District of Columbia under the Federal Religious Freedom Restoration Act. When applicable, the federal RFRA requires government actions that place a substantial burden on religious exercise to satisfy the strict scrutiny standard. In Capitol Hill Baptist Church versus Bowser, the district court determined that the district's order, District of Columbia's order, prohibiting the church from holding outdoor worship services with appropriate precautions failed the strict scrutiny standard. In reaching the conclusion, the court observed that the District of Columbia substantially burdened the church's religious exercise by prohibiting the church from meeting together as a congregation, which its faith requires. The court also determined that the District of Columbia failed to demonstrate a compelling interest in banning the church from gathering for religious worship outdoors while wearing masks and socially distancing. Additionally, the court found that the less restrictive but equally effective alternatives were available. In its reasoning, the court concluded that the lesser demanding standard of Jacobson was not the appropriate standard. The court also observed that DC had undercut its position in that Mayor Bowser had encouraged mass gatherings for purposes of peaceful protesting, and that the District of Columbia had allowed dining establishments to serve meals outdoors with no restrictions. In litigation raising claims under state RFRAs and other state laws, courts have invalidated public health orders restricting religious services. For instance, in Kentucky, Maryville Baptist Church challenged 2 orders of Governor Andy Beshear under state RFRA and the First Amendment. The Sixth Circuit enjoined the enforcement of these 2 orders against the church, finding that the church was likely to succeed on its claim that the governor's order substantially burdened sincerely held religious practices like conducting drive-in worship gatherings, and that the orders were not the least restrictive means of achieving the government's compelling interest. The court also determined that the church was likely to succeed on the First Amendment claim because the orders failed strict scrutiny analysis by prohibiting religious activity while creating exceptions for comparable secular activities. Additionally, in a number of jurisdictions, state and local officials have adjusted restrictions in response to litigation or demand letters from legal counsel. In conclusion, although some of the current conflicts should resolve as effective vaccines and therapeutics become available, additional conflicts will emerge in the future as public health authorities consider mandating vaccinations for COVID-19 and flu. Governments will likely mandate vaccinations for healthcare workers and first responders, but they will likely also consider mandating vaccinations for vulnerable populations and even the general population. These conflicts will pit governments and the communities whom they represent against individuals who object to mandated vaccinations on religious grounds. Additionally, if public health advocates and authorities seize upon the present public health crisis to advance the broader agenda of the new public health, the conflicts will extend into other areas and continue. However, the strict scrutiny standards should lead officials to more carefully constructed restrictions and exemptions that strike an appropriate balance. And with that, we thank you.
All right, Jeffrey Michael, thank you very much for that. Our final speaker is Professor Dwight Newman, Professor of Law and Canada Chair, Research Chair in Indigenous Rights and Constitutional and International Law at the University of Saskatchewan. Professor Newman, let me give the floor to you.
Okay, and thank you for having me as part of this. I'm very sorry I wasn't able to attend yesterday due to a conflicting commitment, but I've very much enjoyed the discussion today. Does the coronavirus pandemic justify the government telling churches how to run their worship services? That's a question that I asked during the North American reopening phase of this past summer. And I identified at that time some very concerning aspects to the policy precedents being implemented. And I'll mention some of those today. as well. But I think now this bears also on future reopening. But also, I want to raise a question about the possible importation into religious freedom contexts of a norm from another area of law. And notably, I want to discuss ideas related to consultation with affected communities in advance of the implementation of policies that may harm those communities. And there's a great salience with some of the discussion in the other papers as well. But there's significant legal doctrine on this norm in the context of Indigenous communities. And I'm not necessarily arguing for making the same kind of justiciable norm in the context of religious communities, but I think this kind of norm could and should provide guidance to state actors in respect of the church-state interface in situations as we've seen with COVID. Obviously, as fall and winter have come on in the North American context, we're back more to questions of emergency shutdowns. There's important religious freedom law that bears on those questions, including the recent decision in Roman Catholic Diocese of Brooklyn v. Cuomo, which has been referenced earlier. My comments are using examples mainly from the summer reopening phase, but they could also bear on measures in the context of the second wave of COVID this fall. What's different about both the summer reopening and the fall second wave compared to the first wave in March is that there has been time to plan and potentially to dialogue on aspects of the policies that would now be adopted. Nobody would deny that COVID presents an ongoing emergency in some senses of the word, but different phases of a longer term emergency can differ in the terms of the amount of time available to prepare for them. And that has implications rather for appropriate state engagement with religious actors. There can be more acceptance of a mistake that the state makes on March 13th when they're making an urgent decision versus when they have the chance to pre-plan for summer reopening or even to pre-plan for a next wave of COVID in the fall and winter of 2020-2021. Some state governments in the United States and provincial and territorial governments in Canada seem to have thought during the summer 2020 reopening phase of the pandemic that they could simply decide how to regulate worship services. And in my view, there were some concerning precedents of relatively detailed governmental regulation of religion that emerged at that time. Other governments at the same time, in the same circumstances, managed to engage with religious institutions more respectfully and furthered health goals during the same phase of the emergency without imposing detailed requirements on religious services in the same top-down manner. And I think that's an important contrast to highlight. So I'm going to highlight some examples a bit quickly. I have more of these examples from the guidance documents at that time than I'll reference in full. But the various state governments and in Canada, provincial governments created these guidelines or guidance documents that related to what was done, in some instances, even in religious worship services. So, for example, California's guidance document during that phase, perhaps most widely discussed in some respects around this point, included the restriction places of worship must therefore discontinue indoor singing and chanting activities. Different regulations on singing during worship services appeared in other states. In Washington state, there was a ban on choirs, but it was specifically permissible to have congregational singing as long as people wore masks while doing so. New York State's guidelines had a ban on singing unless there was a 12-foot distance between individuals. So some different approaches there. Some governments imposed requirements to record contact information for those attending worship services during that reopening phase and to maintain that for a period of time. British Columbia in Canada, for example, had such requirements and a requirement to keep records of that for 30 days. And there are reasons possibly for that, but a willingness to register attendance at a place of worship could affect some people's readiness to attend, especially if they're not regularly involved, or some would have worries about more concerning governmental uses of those kinds of registration lists that would also be pertinent. There were also some jurisdictions whose guidance documents specifically regulated liturgical or sacramental objects, sometimes naming them indirectly, sometimes even naming them directly. And although, again, one can understand that there are some reasons for ideas such as prohibiting the sharing of a communion cup at a time when that could transmit disease, it's nonetheless very problematic in some respects to have the state passing laws that specifically name liturgical and sacramental objects, as was the case in some of these jurisdictions. So I mean, it's at least highly delicate to have the state doing so. So that's one side of things. The other side is that some other states facing the same reopening phase engaged very differently with religious communities and entities. So Tennessee's guidance document opened with an affirmation of the value of communities of faith and their First Amendment rights, and it explained that it had gone on, or that the document had been developed out of various suggested protocols from faith communities themselves, and then was being offered back to them as a courtesy for their convenience. And that's a very different attitude that's manifest within the document. Other documents also specifically referenced rights to religious freedom or rights to worship and free exercise. Or they referenced the possibility that places of worship might make decisions in light of the best judgment of religious leaders. So again, a very different attitude in terms of what some would call freedom of the church, some could call church autonomy, some could call the sphere of jurisdiction for religious entities separate from the state. And there's a sharp contrast there. American and Canadian federalism both revealed some sharply differing governmental attitudes towards religion and towards the church-state interaction. We could identify that in other contexts as well, like in differences around whether jurisdictions identified religious services as an essential service during phases where that's been important. So with the time that remains, I want to reflect on this other norm that I suggest could relate to this distinction and could provide a path forward in some respects. In another human rights context, that concerning Indigenous rights, there's been the development of significant bodies of norms and laws on the concept of pre-infringement consultation with Indigenous communities. And Canada has a particularly substantial body of case law on what we call the duty to consult doctrine. The idea of it is to minimize negative effects on Indigenous communities' rights by requiring governments to proactively consult with them when contemplating government decisions that might have an adverse effect on Indigenous rights, whether Aboriginal rights or treaty rights, in terms of certain Canadian distinctions. Just what's required in terms of consultation is calibrated to various factors that pertain essentially to the potential degree of adverse impact on rights. There are complicated aspects to how that analysis is applied, but what's always sought is meaningful consultation, which involves the government genuinely providing information on what it is that's being contemplated and what could result from that, listening to responses from communities about the potential impacts on rights, and then showing evidence of having considered what it had heard and considering that when making the decision about what the government's going to do and potential variations on that. And a key aim under this doctrine is to minimize negative impacts on rights. In one sense, we could see it as aligned with legal doctrines that call for minimal impairment of rights as part of the test for justified infringement, or parallel elements of different kinds of scrutiny analysis in the American context, which isn't part of the same worldwide proportionality analysis in quite the same way as a lot of other jurisdictions are. But it also serves purposes of furthering what is often called reconciliation between Indigenous and non-Indigenous communities in the context of a complicated colonial history, or just good relations between communities generally. So the Canadian body of law on this is actually very complex and technical, and has become so. I've written actually 2 books on the doctrine, so it's complicated. And I don't suggest importing it directly, but I think, and I'd also acknowledge quickly, that the issues between the state and religious communities are different than those between the state and Indigenous communities. But there are various misunderstandings between the church and state that are even probable in the context of a lot of secularization, especially in some of the layers of government bureaucracy in a lot of jurisdictions. An idea like pre-infringement consultation may help to lessen negative impacts on religious liberty and to promote better relationships overall. Even adapting it away from a sorry, I don't know why I can't say the word today, but a doctrine that's judiciable for present purposes into a norm of governmental practice, pre-infringement engagement with religious communities would seem highly appropriate, even as just a norm of governmental practice. What some states did in their policies during the summer 2020 reopening phase showed that kind of respectful engagement. And there are arguments in larger bodies of norms that can support that. So I think that this is a way of understanding what some governments did that others didn't. Now, there could be a key objection at parts of my argument. Some would object that states needed to take the steps they did because some religious communities did unreasonable things and ended up generating super spreader events. And I guess there are examples along those lines. I think Brett rightly pointed out earlier that there was a lot more attention directed to those in the context of a few religious communities that had such incidents, when there were a lot of secular contexts that also had such incidents and didn't get the same kind of negative attention. But it may be that there might be a different relationship with different states, or sorry, with different churches in light of that. In the context of the Canadian doctrine on the duty to consult, there's certain expectations around the good faith engagement from both sides. And I think there would be ways of adapting that kind of element to the norm over to this more generalized norm of pre-infringement engagement. And there could be an expectation of good faith involvement in the engagement by religious communities. If some chose not to engage reasonably with it, there might be more argument that those particular churches could be subject to a different state interaction than those that do engage very reasonably with it. That lends itself to issues around equality between different churches, of course, and some challenges that arise from that. But I would just say that in wrestling with these complicated intersections of different interests and different rights issues, that something like a norm of pre-infringement engagement could have some potential to find a way to minimize negative impacts on religious groups, and that some states actually seem to have done that, and I think did that very positively. And I'm low on time, so I should wrap up there, but I'll just say that there may not be easy answers on the path forward, but there are some real dilemmas there in terms of the interaction of law, religion, and coronavirus. But I think that this might be a norm that could be advocated and developed in different ways it's very reasonable that churches don't and shouldn't want the state regulating detailed aspects of their religious services. There have been some worrying precedents developed in the context of some phases here that may be even more dangerous because they've been subtle, but there would be alternative approaches that could be developed and that could lessen the harms that ensue from state action in this area. So that's my thinking, and I'd very much welcome any feedback or questions on that as I go on to develop the final version of the paper.
Thank you, Professor Newman. It is interesting just to see how robust and varied are the tools in the legal toolkit that we have for dealing with what feels like an unprecedented crisis, but which really isn't unprecedented. I've just been sort of keeping a tally, and I mean, we have basic rules against arbitrary action, having proper authorizations for government, that the right people are acting within their authority. These are related to basic rule of law type standards, requirements. That seems like a minimum threshold, but a meaningful threshold that sometimes states violate. We have principles of non-discrimination, basically trying to figure out how to treat like circumstances alike. What counts as alike, of course, is complicated, as we've seen, but that is actually a pretty useful principle. It's useful for us to be thinking about how similar is the activities in a casino versus in a church. They may be more similar from an epidemiological perspective than we might initially think. And this might be related to the general and neutral requirements of employment division versus Smith, for example. A third tool we have is the idea of reasonable accommodation or exemptions. And we're pretty adept at reaching accommodations in many areas of the law. Think of disability law, for example, and our ability to accommodate difference and special needs is something that we do as part of the ordinary course of business in many areas of the law, including religious accommodation. The doctrine of church autonomy. We've had several people discuss this at some length, including Kathleen Brady and Cole Durham, pointing out that this is more than just simply a recent doctrine to address personnel matters. It really reaches back into very early disputes within religious communities over church property, for example. But there are very important dimensions of autonomy that are also well developed and understood in the law. The compelling state interest test. This is a test which we've seen applied and that can also offer guidance in non-litigation settings when we're negotiating and thinking about what the regulations and limitations ought to be. We can be thinking about how compelling really is this interest here now, and what are the possible alternatives to the sort of maybe blanket or draconian rules that are under consideration. This, of course, is closely related to the doctrine from the European Court of Human Rights jurisprudence in many other countries, Germany, Canada, etc., having to do with balancing and what truly is necessary in a democratic society. Cole mentioned in passing at the end of his presentation the German concept of practical concordance and the possibility that we can look for strategies of mutual vindication of rights that are often viewed as being in conflict. And then thanks to Professor Newman, another one that I hadn't even thought about, which is, this idea of the duty to consult. And that also is closely connected, I think, to what Alessandro was describing in Italy, that under the Concordat system, there is sort of a natural system of consultation which takes place there. And so it may be that we don't have one size fits all solutions to the problems that ail us, but it might also be that we have tools in our toolbox which are more familiar and readily available than we might initially think, especially in the early days of a crisis, when it feels like everything is unprecedented and on a scale of danger, which is difficult to estimate. So we have a few questions that have come in. I'm going to start with the two that came in for you, Alessandro. I'll ask you to be brief in your responses because there are questions that have come in really for each of our speakers. Alessandro, for you, the two questions that came in had to do with non-derogability of religious freedom and considering religious freedom under the Concordat system, whether that somehow makes it subsidiary as a right. And the second question for you had to do with whether you're familiar with other countries with concordats and how the implementation and negotiation of restrictions have worked in those countries. Alessandro?
Yeah, very briefly, the Concordat system is not alternative to the system of religious freedom because, as I tried to explain, religious freedom incorporate both the two dimensions, institutional, so the relation between state and church, and on one side, the duty for the state to grant individuals and collective religious freedom by unilateral laws. So the Concordat and the unilateral action of the state goes together, and they shape a right that in our constitutional doctrine is already born with its own limits and is balanced with other fundamental rights. The problem is how to balance internally to this right the concordatarian part and the unilateral part. So the general part for everybody and the law specifically tailored for concordatarian religions. This is the tension. And for this, I really appreciate the exposition of Dwight Newman because in Italy, we had exactly the problem, in my way, that the protocols are too much entangled with religious order. So they have used two liturgical expressions, and maybe we could manage the situation just with a general rule that can just leave religions with their own autonomy to cope with general disposition for everyone. Because if not, this kind of protocol don't consider many religious associations that are not in this system of protocolization. So this is a problem of balance. And in fact, in other concordatarian countries, for example, Spain, or also in Germany, we can find more general unilateral norms. Within this frame, each religious group can decide how to distribute the Eucharisty, how many times the priest has to wash his hands, how many people have to serve on the altar. But this is more typical and is a typical religious laws that are not to be too entangled with, in my way, what is the general regulation made by the state.
All right, let me turn, Cole, to you. The question that came in has to do with essential services and whether religious gathering, religious worship ought to be considered a essential service. And what would that mean? It doesn't make it an absolute right, but as a practical matter, what does that classification mean under your way of analyzing the situation?
Yeah, so I take it that the question from Nick was in part, does the fact that it's a freedom of religion right make religious worship sort of automatically constitutionally essential? And I mean, there is something to be said for that. I think what I'm conscious of and what I've been grappling with is that what we're really dealing with here are some rules that have a strange structure. That is, the church autonomy doctrine like, say, registration laws governing churches, they're intended to facilitate, to have a uniform principle that facilitates difference. So there's a certain sense in which there's something on the surface contradictory going on, but it's a contradictoriness that reflects freedom. And the reason I answer this way is I think that yes, what religious communities think of as being essential should be constitutionally protected, but what's essential may differ from group to group. That's the complexity. So, for example, there's been some talk about the impact, the differential impact of shutdowns on religious communities that have sacramental practices. The Church of Jesus Christ of Latter-day Saints has sacramental practices, but we also have a lay clergy. So what happened when the church, which was very quick to shut down normal worship services and also temple worship was more complicated, but the general worship services, we just started having meetings at home, and we could perform our own sacramental services, so it was not a problem. But that might be a very deep problem for someone else. So the point is, yeah, it's clear to me that that First Amendment makes religious things essential, but the essentiality is going to differ, and it's that difference that has to be taken into account. And the reason I like the autonomy approach is well, as Perry Dane has pointed out, religious autonomy is like wholesale. It's not retail, individual versus the state, but it's all religious communities need it, but they need it in different ways. I really like that.
So next, I've got a question for Professors Hammond and DeBoer. You can see it in the chat. It's basically having to do with, can we really justify having a compelling state interest test, which gives a high level of protection to religious actors when some at least are behaving in ways that are very irresponsible? And you'll want to unmute yourself.
Okay, can you hear us now?
Yeah.
Yeah, I hear the concern about the potential that there could be some communities, faith communities, that act irresponsibly. And of course, that's true across society. I don't know that there's anything unique about religious communities that would suggest that they're more irresponsible than those who might frequent, bars in university communities or so forth. But one of the things that I've observed is just how responsible faith communities have been over the course of the last 9 months. Churches that I've attended and people that I have contact with have been very careful to go above and beyond the guidelines that have been put in place by the government. So there certainly are those examples of people behaving badly, or maybe religious communities behaving badly. But I don't know that decides the standard question. What is the appropriate way to go forward with balancing?
Anything else to add to that?
Yeah, I would say this. I don't even know if you can make a distinction based on large churches versus small churches. My church is a small church in East Montgomery, Alabama, and we've taken lots of precautions, including breaking apart the chairs on which congregants sit into what amounts to puzzle pieces. So family units can sit together, but they're distanced from each other. For every John MacArthur in his Grace Community Church in California that says that the pandemic isn't real, there's Capitol Hill Baptist Church in Washington, D.C. that tried to meet, but also wanted to meet with lots of distancing and mask wearing. So outside even, as Mike points out, I don't know if there's any type of point in time or any type of example that would say that the strict scrutiny would not be appropriate.
Thanks. Professor Newman, let me conclude with you. We've got a couple questions here in the queue. One has to do with distinguishing various limitations that are generally viewed as permissible, at least in some places, such as restrictions on animal slaughter. There's a famous US Supreme Court case which held that that kind of prohibition was unconstitutional because it was so clearly targeted just at religious exercise. But how do you, are you thinking about sort of the limitations on singing or the communion cup in the same way, or is it a different type of problem? And the second question is what we would call the Establishment Clause problem in the United States. The idea of consultation would raise the specter of entanglement of church and state, or a violation of the wall of separation of church and state in the United States. From a Canadian perspective, do you think about the anti-establishment issues? And does that create any challenges for bringing the analog from the indigenous rights context into sort of a church autonomy context?
Okay, thanks. On the first of those, I guess I would say when I'm speaking particularly on the communion cup, there I'm talking about government regulations that actually name the communion cup in the regulation. And so I do see it as a targeting that would be analogous to that you've referenced in the American case on animal slaughter. But I mean, just the degree of detailed regulation that's specifically aimed at houses of worship is particularly what caused my attention to be drawn here. There are obviously other issues that arise in terms of the justifications that are present in these different situations and the strength of those and so forth. But it is the particular focus on religious services that I think possibly distinguishes this from some of those laws, but would align it with the American case referenced. The entanglement question, I guess thinking about this across different jurisdictions, we all start with slightly different assumptions, and Canada doesn't have a formal non-establishment clause, although the Canadian court has moved significantly in recent years to develop judicially something very similar in some respects. But it's a good question whether there would be any worries of running afoul of entanglement principles in the US. I'm tempted to guess that that could be avoided because something like the process described in the context of the Tennessee guidance document doesn't strike me as involving entanglement in the ways that have caused concern. If it's just a reaching out and listening to what churches say about the churches or other faith traditions, houses of worship say about what the impact could be upon them and developing rules that minimize that. I don't think that strikes me as entanglement, but it's something I should look more at to the extent that I'm saying anything in the American context.
Yeah, it's one of the great things about comparative study is that we get new insights and ways of thinking about things that might apply in slightly different ways, but might also have relevance for us. Thank you very much to our panelists. You know, it occurs to me as I've been thinking about these issues over the last few months that the health metaphor is going to be very important. I mean, this is obvious in one sense because we're dealing with a health crisis, a pandemic. But the idea of restoring ourselves to health, our institutions, our relationships within the institutions that we belong, and also thinking about what health means. I've been reading Rabbi Jonathan Sacks' latest book, Morality. He was the chief rabbi for the United Kingdom, passed away about 2 weeks ago. Someone whose work I've deeply admired over the years. And his passing motivated me to read his book. And he was talking about health. And he was at the doctor and he was on a treadmill. And they were having him walk on the treadmill. And he asked the doctor, "What are you trying to measure? Are you trying to measure how fast my heart rate rises, how high it goes? What exactly is the purpose of the test?" And the response was, "We're trying to measure how quickly you recover." And I thought that was really interesting because I had never thought of health as being measured by sort of how quickly we recover and how resilient we are and how soon we can return to the robust condition before the stress test of walking on the treadmill or the stress test of the COVID pandemic. And so as we think about moving forward, as we think about the post-pandemic world, as we navigate our way out of this crisis, one thing that I've been thinking a lot about is how do we facilitate processes of recovery that will help us return to health, not just physically from the infections that are affecting different people in different ways, some severely, some more moderately, but how do we recover as a society, and how do we recover as churches, as institutions that are important in our lives? All right, so I think our plan is to take about a 5-minute break and then to convene for an open discussion about the road ahead. Is that right, Nick? Let me turn it over to you and you can give us instructions for where we go from here.
Yes, sure. Thank you for those reflections, Brett. I think they're pretty profound and in fact, they dovetail very nicely with what we were hoping to do next. This has been a very rich 2 days of sharing of papers and experiences from Europe and from North America. And, you know, it could end here in a sense, and we turn off the Zoom and we all go back to our lives. But I think that that what Brett is talking about, you know, there are some things that the pandemic is teaching us that despite maybe some of America's worst impulses, that we want to turn inward, that we want to disconnect from international affairs and concerns, the pandemic has sort of proven that's not possible. You know, somebody gets sick in Wuhan, China, and 3 or 4 months later, we're all in our basements. It's got to tell us something about the importance of international engagement and engagement on the issues that we're having here today. And I want to share with you, we will take a 5-minute break for those that need to, but I'm going to share with you a website that we've created that has promoted this conference. Many of you may have seen it because that's where some of you needed to register, but it's also going to be where we'll place papers and the videos of this event, so you can have access to them as an ongoing resource in whatever work that you're undertaking. But we also want to talk about the possibilities that this website might present as a forum, as a bulletin board, as a place where we can continue to update each other informally over the coming months and year. You know, does anyone doubt that we will probably be dealing with some form of balancing of regulations and worship and religious freedom for at least 6 months to a year? And this experience has almost guarantees that we will continue to wrestle with this for some time to come. So we're going to talk about what we might do as a group with our expertise in terms of bringing that expertise to bear in the public arena in ways which can be helpful to us and our institutions as we practically grapple with these things. So let's take 5 minutes. I have 1:35. I'm not really going to go away. I may grab a drink, and at 1:40, I'll start walking through this website and lead out in a short discussion of where we may go from here. So thank you. Well, all right, it's 1:41, so let me jump in here. What I'm sharing on the screen with you is the website where the conference registration was located. And you can see there on the left side of the screen is the conference schedule. And if you clicked on that, you would be downloaded the PDF of this 2-page program that we've been working on. Hopefully by next week, that conference schedule, there will be a link there to actually link to the conference papers as well as to the videos of the conference. So keep track of this website here, this religious liberty. It's www.covid-religiousliberty.org/events. I'll take you to the home page now. And I'll, of course, send out a copy of this link to everyone who's participated in this event. This is a website that my university, the International Religious Liberty Institute, started putting together last spring. And Alexi and I worked on a joint project, a research project. We decided to do a kind of comparative analysis of legislation at the state level in the United States, as well as a analysis of the European legislation across the European Union, looking at where religion was restricted from low, moderate, high to very high, and using a similar kind of analysis that we used in the United States. And we've written a bit of a paper, which we've also haven't fully completed yet, but is available on this site. It's a bit of a historical snapshot. In other words, this is what happened in the first, at the May-April point of the pandemic, when things first began to lock down. So it sort of shows initial impulses and immediate reaction to events. Obviously, it's a moving and a changing target, but for just a couple of scholars to keep on top of it is not really feasible or possible. But it again represents a nice piece of history as to what happened, at this point about 8 or 9 months ago. We were considering the possibility of trying to work with some other scholars to keep this updated on a going forward basis. And also, this group here, I think we've mentioned a couple of times already, a number of the experts here are also involved in an organization called the International Religious Liberty Association, whose journal we will be publishing these papers in. And while this isn't a formal meeting of that organization, there are several of us, as I said, who are involved with it, and they have meetings in the fall on a regular basis. There's one, I believe, being planned for Geneva in September. The academic institutions that Brett and Alexi and I are involved with, we have enough interest in this topic to try to perhaps sponsor some sort of working group over the next few months to share information on legal developments in relation to COVID-19 and religious freedom, both here in the United States and in Europe, and possibly work together to, we think that often that a contribution that could be made is the kind of expertise that we bring to this in terms of legal analysis from a public policy perspective, that right now, everyone is dealing with these questions of the balance of health and religious freedom. And something that IRLA has done in the past, which has been of help, is to write short statements of principle, not much longer than sometimes 2 or 3 pages, maybe 4 or 5 pages, that set out the values and concerns represented by the issues that are apparently at conflict here. There's health concerns and there's religious freedom concerns, and both of those are legitimate. Sometimes the left wants to make the health concerns paramount and religion always loses, and on the right, sometimes there's an insistence the other way. And where a community of scholars can contribute is to take seriously both sets of values and then set out in a relatively succinct paper how these things might be thought of both at the level of primary principles and then some secondary principles, which gives a document which allows people to make a application to particular circumstances or to particular places. So what we're wanting to discuss for the next few minutes as a group is, so clearly we already have this resource and this website, which all of you are free to use as we put up the papers and the videos. And so that's done. The question that we really need to talk about is perhaps twofold. Is there any interest and willingness to contribute updates from where we are and in our areas of expertise in an informal way, maybe as posts or as short blog items on this website to provide updates, and or to even consider the possibility of meeting in some sort of working group, maybe once every couple of months, bi-monthly, to see if we could construct a 2 or 3 page, 3 or 4 page short white paper summary of how best practices from a group of international scholars who care strongly and believe strongly in religious freedom, how to balance religious freedom and health concerns during a pandemic. So that's sort of the idea and a proposal we're putting out there. It wouldn't be under the umbrella of the IRLA, but it could be a group that might bring to the IRLA a proposal or suggestions or a white paper for them to consider formally joining and supporting as well. Okay, let me, maybe it would be good, in fact, for Alexi and Brett, who we've previously sort of talked about this, to weigh in and give their views, and then we can open up the floor more broadly.
I don't want to speak too long, so I'd like to hear other people's ideas, but yeah, I definitely second what you said, Nick. I really like the formulation that Brett had at the end about this idea of our ability to recover. And it seems to me that kind of going forward in terms of what the outcomes, the outputs might be of this forum and similar fora that are thinking about this question. One is about, it seems to me there's a real need to document the debate and document the evolution of the crisis, so as to have something to look back on and to evaluate it. And just as an example of that, this is it's a document that just came out. We collaborated on this with colleagues in France. So it's led by Emmanuel Hirsch, who's a professor of medical ethics at the central hospital in Paris. It's called Pandémie 2020. And the idea of this, it's quite a considerable volume, which we got out quite quickly. But the idea of it was to have a multidisciplinary snapshot of what the key issues were in the heat of the moment. And I think these online forums that we're doing that allows us to reflect on that, but also being able to inscribe that within a document that we can come back to later on. That seems to be, to me, to be worthwhile. And then the second related task seems to me, what Brett was talking about, some sort of project of monitoring the recovery. It seems to me that the big question or the big risk now, not only in matters of religious freedom, but in matters of the general organization of our individual polities, is going to be to what extent we're going to retrieve certain freedoms and retrieve certain balances of powers between the citizenry and the government. And it seems to me that we could also have an action-oriented space of thought for that.
Brett?
I don't have much to add other than to say that, we just thought it would be useful while we're sort of fresh in our minds of the interactions we've had over the last 2 days to just brainstorm. And so I think what we'd like to do is sort of gather as many ideas as people have, and to then try maybe constructively about whether there is anything concrete that we'd like to try to do moving forward.
Okay. So there you have it. I spoke with Alexi and Brett ahead of time, and the three of us would be willing to work with our institutions to help continue to provide this forum, at least for the next year, if there's an interest in doing something moving forward. So let's hear from those who've attended. Looks like Cole.
Yeah, let me just react. I have a number of sort of quick reactions. One, and part of this is I'm involved with the G20 process, and I know that we have a set of working groups, one of which deals with religious freedom type issues, and we're looking for expertise on some of these kind of issues because COVID will obviously be a big issue. And so if there were some interest, one of the output products could be something like a policy brief that would ultimately go to G20 leaders. We're anticipating that we'll be urging the Biden administration to move promptly to sort of get more actively back into the G20 process, and that's a context. The G20 is basically 19 countries plus the EU, so it's any of you. But Italy is the host this year. We had the handover today for what we're doing, but that might be a place where some kind of policy brief could be done, and I think it could be quite welcome. And Ganoon is on our advisory council, and I think that could be thought about. As I looked at the website, just obviously just glancing at it, was not clear to me what is behind the maps. I mean, I can imagine one of the things that would be useful is just gathering ongoing data, having copies of legislation, copies of court cases, and that may be what's there. It may be sort of what you would like to have there. It's the kind of thing that you really need people who are local to be able to do, but that would be a kind of useful thing to have. Jean-Francois Mayer talked about, I mean, he's done big projects like this on different kinds of things around Europe, and he talked about the masses of data he's dealing with. I'm not sure exactly, what's at stake there, but I think that just in addition to having a way to gather the basic legal materials, that is legislation, regulations, cases, and I guess other practices or things that are happening, it's some way of something that a group would need to do is really figure out how to order that and how to have some systematic way of organizing everything you have, which would take some thought. But it would be helpful to know more about what's there, what the potential is, how easy it is to upload things, and so forth. It might also be helpful. I don't know that I'm not thinking about a survey that one would send out or something like that, but just something that you could kind of help identify what things you want to look for on each of the laws, statutes. I mean, how are you judging, you know, red, blue? I can't remember all the colors you had on your map, but what are the criteria? And I guess the other thing, just in terms of practical places this could really have impact, it's very clear that the really hot issues right now are how vaccines are going to be distributed and how that's going to be done in a rational, fair, equitable way. And also whether the patterns we saw earlier with PPE would sort of restrict trade, America first, China first, or would, because one of the things that was happening is that trade was being demolished and it was just making it very hard for everyone to get things. Can that be dealt with? And the more general healing issues. So I think there are a number of practical areas where something like the statement you talked about would be helpful. Something that's a step beyond the statement is a kind of policy brief where you've really got some people who really know the data, know the field, and can say something that will have some bite with actual policymakers would be important.
Okay.
If I may just.
Yes, Michael Wiener.
Yes, thanks a lot. And just picking up this idea and also the practical side that Cole was just alluding to. So this policy brief obviously could be very useful in addition to the website. And what about just as a brainstorming idea, also flagging specific cases, legislation, or when it comes to vaccines, discrimination that you see in the various countries or states, to United Nations human rights mechanisms, be it special procedures, the Special Rapporteur on Freedom of Religion or Belief, for example, on minority issues, or to treaty bodies. So just to have this as a potential, very practical channel of flagging this to the UN mechanisms. Thanks.
Good suggestions. Anyone else? I think what we need is, you know, people in Europe and the United States who would be willing to send us material when there were new decisions or new legislation, and then we could put it up and make it available to everyone and act as sort of a clearinghouse for developments. And I mean, I don't view it as an overly burdensome operation in terms of we're not really asking for original commentary unless people want to give it, but a place where you can go and see what the latest is in various parts of the world, at least at this point, North America and Europe, the European Union. Does that seem plausible? Does it seem doable? Are people willing to send information along like that to us? What is
My guess is people would be willing to do it. One of the things I'd suggest is you might want to develop some kind of form, because we've certainly tried to gather in general church-state information for websites that we've set up, and it's difficult because it comes in multiple forms, and what you want to have is something, just some basic things like in English, because many things might come in other languages, but just something that's a brief title of what it is, and how you cite it in the legal system that it's coming from. Just some basic data that could be provided so you would, as things came in, you would gather it. The other thing I would say is just have a particular email go out every month or so, just say, have you seen anything recent that could be submitted. I mean, getting a sort of comprehensive sets of things is harder, but it still would be useful to gather what comes in and what is coming across people's desks. And I think most of us would be willing to try and respond in that way. And with enough people from enough places, you'd start getting significant collections. And then you'd have some people who are really aggressively gathering this information professionally anyway that could be shared.
Yeah, go ahead, Professor Meyer.
Yes, if I may suggest, probably beside legal decisions, it might be important as well to list significant research articles we come across, not only about purely the legal aspects, but also those articles describing national situations and so on, and developments, because this would help probably to put legal decisions into context. And I see really an amazing number of call for papers, also from regional studies. I think, for instance, the other day I saw a call for papers from a journal on religion in Latin America and things like that. And don't forget, we have focused on North America and Europe, but obviously Latin America has been really harshly stricken by the pandemic. And so it might be interesting not just probably to have a repository of legal decisions. I think this would be great. But besides that, probably to have not something exhaustive, but at least when we come across articles we deem to be interesting, significant, not any media report, but research articles, that might be probably quite useful, because I just try to keep an eye on them, and it was possible during spring, but now I must say it's no longer possible to screen all the articles coming out of very, well, different levels qualitatively.
Yeah.
Just to respond to the issue that Cole raised about what's behind the map. I mean, so what's behind the map is our best efforts, just Nick and I at the time, under conditions of lockdown, to try to collect that data. And one of the things that we were facing was just how much of a logistical problem it was, and that we would need some form of support, some form of collaboration, some form of funding if we wanted to do it in a really robust manner. And I've exchanged about this with Jean-François Meyer as well. And it seems to me that, yeah, both having those cases, and I think you're right, Jean-François, about having a growing bibliography would be a really useful source of information, because the situation is changing so rapidly. It's very difficult to keep an eye on certain, perhaps very important events that just get covered over in the sand the next day.
Rosa Maria, you were about to say something?
She's muted.
Yeah, we can't hear you. Yeah, okay, there you go.
Thank you. Thanks for thanks for sharing your opinions and the follow-up of this difficult and complex conference. Well, what I feel is your starting point was the data Alexis mentioned. I mean, you started collecting data from the US and from Europe. But what is important in your project is that you are trying to do a comparative analysis in Europe and the US. I know networks working on COVID and religious freedom in Italy, in France, and Spain, but they are not doing what you try to do. It's a comparative analysis. That is what I want to underline, because that's important. And then the website, Nick and Alexis, I think it's a very good starting point. I mean, the website is the connector for all of us. Then we can see in the medium run how many people are connecting with the website, and how many people, how many research can be put on the website, and how many scholars are joining the website. That's the important point. Then we need some sort of experience together to see how can we, step by step, that's my suggestion, I know that a working group can be raised, but it needs time. Okay, what I mentioned right now is that the website is a good beginning. There are many scholars who would like to contribute to the website. I'm sorry. There are many scholars who would like to contribute to the website, and that means sorry. I have some. Okay. Then what I mean is that please, okay, don't. I mean, put it. Make it effective. Okay. Thanks.
All right.
Okay.
I was going to ask you, Cole, you have a lot of experience in the international arena in these questions with the G20. Are you familiar with something like I talked about earlier, like a nice clear distillation of the principles related to
yes, I can.
health and religious freedom, Cole? Do you think, do you know of any such document? Is that something that would be useful to contribute on? What are your thoughts about that in particular?
I think it would be useful. In the United States, there's a really good document it's like a vast Google document that was done by Catherine Marshall at Georgetown and some colleagues of hers. I'm not sure how aggressively they're keeping it up. They may have encountered both exhaustion and overload, but I can send out the link to that. But it just went through day by day, and they had sort of daily one-page reports on things happening, but they sort of collected. It's like a headline assimilator for all kinds of documents that they were finding. So there is that, but I'm not conscious of something. It would be helpful to know if there are some national or regional people in Europe. Rosa Maria just mentioned Spain and Italy. There may well be some things, but and obviously WHO has some things that they're doing. But I think it would be a useful thing. I'm not aware of a study that has really pulled together in a comparative way all that's happening legally in the response to COVID.
Well, I guess I'm not looking necessarily for a comparative study, but for a clear statement of religious freedom principles and how they should be balanced and weighed and applied in a pandemic. You know, sort of not what everyone's doing, but an attempt to make a normative statement about how scholars of religious freedom that take it seriously, but also take health seriously, you know, would go about thinking about this. Now, Andrews University, we have a sister school that's a medical school. You may have heard, some of you, of Loma Linda University, and I have friends that are there that are medical researchers and bioethicists, and you know, bringing some of them into a group of religious liberty scholars and experts, perhaps we could create something that could speak to this with both intelligence from the medical side and the religious freedom side, and create a succinct kind of summary of best practices or the principles to consider when approaching these questions.
Yeah, no, I think the kinds of things that IRLA has done in the past, I mean, this could fit in that kind of format, but it would be a very useful thing to do. It might be that you'd have something that would be, you know, the 2 or 3 page sets of recommendations could be backed up by some appendices with more detailed sort of factual information and so forth about the range of issues and problems. But I think that would be really useful to do, and I think it could. We've identified some channels here, both the ones that Michael Wiener talked about, the G20 Center thing that I've talked about, and others that would really have some potential impact. So yeah, I think it would be a good project.
See, it seems to me, Nick, that also those aren't necessarily mutually exclusive. Could have a more succinct prescriptive document that would have as its foundation a broader analysis that could be on the website or that could be published in some forum. And definitely the special issue in that we're going to publish as a result of this conference would contribute to that. And
Yeah.
I also think that I'm frozen.
We can hear you and see you.
Because you're all frozen for me, I'm sorry.
John Ney, do you have anything to say about this from the IRLA perspective point of view?
Not really. I know that Ganoon is very supportive of it. I am too, and I'm looking forward to being able to watch the recording of the sessions I had to miss. But I do like the idea of every 3 or 4 months getting back together briefly or little updates like that, and I'll definitely try to keep up on it. But thanks.
I just got an email from Michael DeBear, and he and Jeff, I think they've dropped. Oh no, okay, we still have. Is it Jeff or Mike that's still there? I can't hear you. Sorry.
Mike.
Okay, Mike. So Mike sent, Jeff and I were pleased to participate in the conference. Thank you for your leadership. Jeff and I are interested in being part of a working group activities. We look forward to learning more in the days ahead. So it seems to me there's enough sort of concern and interest in this topic generally that certainly we're going to have the website and certainly we're going to put the papers and the video up. And if we can, I'll speak with my web designers about creating areas where we can share more general links to articles and news stories from both Europe and the United States to kind of keep an ongoing log. And then the leadership group that we've assembled here, Rosa Maria, myself, and Alexi, Brett, and Cole, will put our heads together and take into consideration what's been said here. And we've got the emails of those that have participated, and we will send out perhaps an idea about a future gathering we could do, less intensive and less in a formal way, more in the way of update and perhaps collective conversation, maybe in a couple months' time. How does that sound?
Yeah, good.
Okay. Well, I do want to thank all of you for participating. Of course, recognizing my partners in crime or leadership here, Alexi from Portsmouth, Brett there from BYU, along with Cole and Rosa Maria from a wonderful country of Spain. It's been a pleasure to work with them all, and I look forward to doing more in the future. And I wish you the best happiness and health and God's blessings over the coming days and weeks for you and your families as we continue through these uncharted waters, both personally and professionally. So thank you very much, and we will see you again, I'm sure.
Thanks, everyone.
Thanks. Bye.